ಮಾಡ್ಕೊಳಕ್ಕೆ ನಿಮ್ಗೆ ಹೇಳಿದೀನಿ ಏನಾದ್ರು ಬೇಕಾದ್ರೆ.
ಹಲೋ ಸರ್, ವಾಯ್ಸ್ ಮತ್ತೆ ವಿಡಿಯೋ ಕ್ಲಿಯರ್ ಇದೆ ಅಲ್ಲ? ಹಲೋ.
ಕ್ಲಿಯರ್ ಇದೆ, ಕ್ಲಿಯರ್ ಇದೆ.
ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ಮಾಡಿ
this appellant rejected the OTS proposal of the respondent. He filed the writ petition. The Honorable single judge will accept.
Urgency.
Has closed my written. They are the proceedings, my lord.
They are. Tomorrow. Tomorrow. You give a copy to Mr. Ramesh, write it. Nothing will happen. Please do it, whatever. Yes. Supply copy. Yes. Urgency. Fresh matter. What is the urgency? Day after. Array, this is 2013 matter. No, but yes, why do you want for final hearing? We'll admit it. What is the big deal? Day after admission. Madam, right for admission. Yeah. Why do you want, Mr. Tell us, why do you want what we perceive it's a fresh matter. Don't get old matters listed, right? What is it? What is the urgency? How long it is pending? What has happened? Why do you want? What is the urgency? Don't do this pro bono for mentioning at least. Yes. Okay. You tell him you want an adjournment, he will give. We have delegated the power of adjournment to our court officer. You tell him. What happens, Mr. Devanand? Every day people watch and every day we resist this prayer. So supposing if we grant an adjournment to you today, every day at 10:30 we have to entertain the prayer. That's the difficulty. No. You want an adjournment, he will give whenever. Admission. What is the urgency? All right, day after. Yes. No, this is not, we don't have arbitration. You go somewhere else. Yes. Please find out where it will be listed, then make a mention, proper place. You want to withdraw? Withdraw this petition. What is the urgency? No, what we are asking him. What final arguments? What is the matter? So it should not be listed for final hearing, right? So then posted for final hearing. So then what do you want? When it is listed? Find out, Mr. What has happened. See the order. Really, we don't know. What are you telling? I mean, you are not sure about it. You don't know what has happened. So we will find out. It was supposed to be listed for final hearing last week. It has not been listed. That's what you say. It should be correct. Otherwise, we will summon you tomorrow. Whatever you are telling is, if it is incorrect, don't.
For the petitioner request for 2 weeks time, my lord, I will take appropriate steps, my lord.
Granted.
Please.
What matter we have granted 2 weeks time? What is there to argue? What is it? Only virus? Yes. It will go before single judge, right? In this writ petition, the petitioner has said validity of so and so provisions of Karnataka Land Grabbing Prohibition Act. a division bench of the reasons assigned. It is, then this will go before challenge before the single judge or DP. 40. The prayer clause is before the division. All right. Good. Division bench. Division. All right. So they have challenged this order also, madam. To a writ of order directing quashing of criminal proceeding. So far as yes. So this is item number 3. We are passing an order. We have granted you 2 weeks time. So land grabbing, so nothing survives now. What is that? Raise all objections before the land grabbing court, right, Mr. Rao? Item number 2. This petition. Summons issued by registrar. You take all objections before the land grabbing is special.
Deputy Commissioner has also initiated similar proceedings in the complaint in the have filed a separate petition that is waiting before this on the court. Have to place the proceedings for
So you raise all objections. You can raise all objections, right? What
is actually before the judge is engaged in one more petition, which I have filed.
But what can we do? This is only an order directing issuance of summons. Validity of act has already been upheld. What can we do? Everybody has to face whatever comes in line. Everybody has to face, not only your client, right? So in this writ petition, item 2, the petitioner has prayed for the following reliefs: ABC. Paragraph 3, we have heard learned counsel for the party that the validity of the Karnataka Land Grabbing Prohibition Act has already been upheld by division so and so for the reasons assigned. The challenge to the opposite act is repelled. However, liberty is granted to the petitioner to raise to take all such contentions as are permissible in law in the proceeding before the Karnataka Land Grabbing Prohibition Special Court. With the aforesaid liberty, the petition is dismissed. Order is item 3 also, right? Yes, what happened? Who is missing?
My lord, for respondent 1 and 2, my lord. My lord, I am in VC, my lord. I am for respondent 1 and 2.
Yes, bailable warrant was issued, madam. What happened?
My lord, I am appearing through VC, my lord. My lord, I'll verify and make my
What happened
submission.
to bailable warrant?
My lord, I am verifying it, my lord. I have informed the Commissioner of Police to verify and send the report, my lord. Please, my lord.
Item 8, office is directed to delete the name of additional government advocate and to reflect the name of Mr. So and so. 2 weeks time. 10 2 weeks, 11 2 weeks, 10 2 weeks.
11, Gautam Raghunath, Geeta Menon.
Yes. You filing, it's not filing counter. What is this? Oh, sorry. Yes. All right. Yes.
Last month.
So that's history now. So we are on merits. So you were married on 2010. Then Your son was born 20, 12/9/2018. Born. And all that. Judgment habeas corpus. That copy. When he was in your custody, right, son? He's 3.5 years. And he has been taken away by respond number 3 on
On 28th
28,
28th February.
52. Taken away without informing you.
Without informing.
From where?
From the residence, the matrimonial court in Bangalore.
How he has been taken away?
He, along with his mother, took the child in a car and had driven away. The police proceedings found out that he was gone.
Oh, you did not know that he took away. He came in your absence.
Together. On 27th, when the father was serious and the news came that they have to go, she pleaded, let us all go immediately. They said no. So she said, all right, allow me to go with the child. They said, no, the child will be with me. You go if you want. So she obviously could not leave the child. So she requested the police on 27th. Police came and spoke to him. He refused. Then on 28th, when his condition deteriorated and she got a call, and she requested the police again. Police then sent her to the women's police.
What happened thereafter on the when this petition
So
was?
the police had gone subsequent to my moving before your lordship. The police went to Chennai because the last base on the.
No. Pursuant to this order which we had passed, you said something happened. What happened? You went to Jaipur.
He said, I will only book the tickets. What he did was his brother's wife's ticket, his brother's ticket, and everybody else was booked on the flight, and she was asked to sit separately. When they reached Jaipur airport.
When the ticket was booked?
26.
26 what, madam? March, April,
March,
February.
26th of March.
So then what happened?
So 3 advocates accompanied them, and then there are 2 security personnel and 1 from Noida, and the sister-in-law's brother again from Delhi also arrived there. They refused to even go to the parents' house, and therefore the husband's family.
What happened there?
They refused to go to the parents' house to stay, and therefore her sister's husband, who is the major general in the army, he requested them, come and stay with us in the army quarters. We will take excellent care of you. And he flatly refused. They called the police. The police arrived and police says, why don't you all just go and stay in a hotel and let's not get into this. The major general in the army says, I do not want to take any action here because that is all they want. Because they want you to file a case over here. Kindly move the court and we will abide by the directions of the court.
All right, so when did you come back, man? In a hotel, right? And
in the hotel, your husband holds on to the child all the time. The sister-in-law asked the child is made the last request for the sister-in-law Rama. And the whole concept is that now even the objections that they serve, that she is not the biological mother, the father is the biological father, and therefore she has no right. This entire scheme of even the lordship was very similar to what we had thought when the abduction happened. Was his brother and his sister-in-law don't have children in the UK, they flew down just to ensure that this child could be adopted by them, and the father would accompany because they can't go through the adoption process here. And so they have also gone to Jaipur, all of them. Now the child is made to call the sister-in-law as Amma. And then the father, they also claim that the father-in-law is not serious. Now,
where is the child, madam? So where is it? It's available, no? Supposing if an order is passed, we will be in a position to comply. Either of the parties, right? We don't know. Fine. Yes. What do you say? You want to file any rejoinder to this?
Say for your lordship that.
Because it will not stop here, right? Please understand. It's better. I mean, you should have said before arguing. No, no. You should have said that I want time to do this.
Not filed it, I didn't.
You only said that don't file it here. This is not filing counter. So go and file, madam. Learn it. Counsel correspondent. Number 2, undertakes to file the statement of objections during the course of the day after supplying a copy of the same to learned counsel for the petitioner. List on what date?
2 days time, but I told it's a holiday on the.
It is a holiday, right? No. Friday 8th. Oh, sorry. 8th April. Madam, advise your clients properly. I mean, this is not a, we will decide, there is no problem, right? We have to write a judgment, we will write a judgment, but this is not a, that day also we told you, what is this? How can you keep 3.5-year child away from his mother? You have started spoiling his life by poisoning him against her, against his own mother. This is what it is. Unfortunate. This is what I mean. The cases come and go. There is nothing. We will decide it. Whosoever succeeds, whosoever loses will go to Delhi. That's for sure. But that is not the solution to this problem. Please understand. That's why we told you on that date that please arrive at an amicable settlement. You behave like this, going like this thing with 3. Fine. Please, for child's sake, you fight it out, your battle with your wife separately, but don't drag in the child. That's what we urge you. And it's our job to decide cases. We will deliver the judgment. Don't worry about it. But it's unfortunate that 3.5-year child is being poisoned against his own mother at such a young stage. What will happen to his personality? You are not going to, you have this thing. You are not immortal, right? You will have to leave the world. The child will remain in this world even after you die. What will happen to him? How his personality will develop? You understand? These are larger this thing. Don't always be an officer of the court. Advise your client properly. Don't listen to whatever always they say. This require altogether different approach, madam. These petitions. This is not the usual litigation. No. This is what we are telling you. We are not asking you to argue on merits. We are telling you this requires a different sort of a approach and a maturity beyond your age. Not fighting with whatever she said. No, it is incorrect. This is correct. No, I had gone there. She has violated her husband. Her father was not dying. He is alive. This is not the argument in this case. You have to be mature enough to give your clients a proper advice because they are influenced by you. If you tell them, no, we will fight it out. I will see to it how the court gives the custody of the child to the mother. No, I will take you to Supreme Court. You have an excellent case. No, don't do it. That's what we are telling. This problem is a human problem. It requires a different approach. That's what we are telling you. Trying to emphasize. If it comes to it, we will decide it on Friday. You will get the judgment. You will get the judgment on Friday itself. Don't worry. What is the problem, madam?
On the last date of hearing, you made a submission that the mother is not a biological mother. That itself shows your mindset. You cannot make such a submission. A submission in the open court is not a biological mother.
But then that is what was recorded in the last order sheet. What's the problem? Why did you take away this thing? You stayed in the hotel, took away your sister-in-law and brother and this thing.
Stating only husband to go.
So you call them, both of them. We'll meet them tomorrow. Your pleadings may be completed, but you call them, madam, list, praise for adjournment, etc. is all right. She will file the statement of objection. Learned counsel, senior counsel, praise for short accommodation to enable her to file a reminder. List tomorrow. What is it tomorrow? 5th April 2022. The party shall remain present on 5th of April 2022. At what time? Yes, at 2:50.
On the last occasion, uncle Lordship was passing the orders. They were online. The moment they felt the supplement, he picked up the child again, ran away, Lordship, even before the order was passed. And once he realized that the matter will be adjourned, then he comes back home, Your Lordship.
Child will be brought here, right, tomorrow. Saying like they have violated the order. Now he's taking a stand. I didn't violate. I have not removed. The problem will remain like that. You should talk to them first. Yes.
Number 12.
Madam.
My lords, I appear for the petitioner in this, my lords. May I request, my lords, may I make a submission, my lords, before learned friend makes submission? That
Course,
yes.
We are just. It can't happen, madam, that without hearing you, the order will be passed. It can't happen.
My lords,
just wanted to know what is it.
My lords, it is a seat matrix, my lords, which is similar to that of what my lords have passed order on 30th of this last month. My lords, in this matter, yes, my lords, the order is, that is 6735, my lords, of 2022. Before that, my lords, I have a submission. My lords,
of course. When was the order passed?
My lords, that is where it is showing only dismissed, but order is yet to be released, my lords, in that. It is on 30th. It is on 30th.
Madam, it really hurts us. We don't know. No order remains unsigned. It has been signed on that very day. It has been typed. And since we have not been assigned the job of uploading, you don't get the liberty to say that the order has not been.
I am sorry, my lords.
Every day in and day out.
I am sorry, my lords. It is
the order on that very day. We don't know. You make a complaint to Registrar Judicial why it has not been uploaded. And
please, my lords,
seek an inspection just now, and whether or not it has been signed. There is no chamber, there is no file pending in our chambers.
Please, my lords,
that very day it has been signed.
I stand corrected, my lords, because it was not. Please, my lords.
When was it listed? When was? You tell us that is the date of the order.
My lords, it was listed on the 30th of March, my lords. It was heard on 30th of March.
So 30th March is the order. Give it.
Yes, my lords. My lords, may I make a submission in this?
She's saying it has not been issued. Why? Madam, where is the order? 6735/2022, 30th March. Where is the order? Why they are saying that it is not issued?
My lords, I'll ask my colleague, my lords, since I am not I could not be present in the court, my lords. And
what is it, madam?
My lords, this is similar matter, my lords. May I make submission, my lords?
No, you tell us, can we take a different view, even if we have decided wrongly against you, but can we take a different view now in a subsequent petition? We are bound, madam.
Yes, my lords, may I request, my lords, because on the day, my lords, the learned government advocate said that all those in-service seats have been filled up. My lords, in fact, after the mop-up list was released, the candidates have seen that there are 15 seats of in-service have not been filled up. And therefore, my lord, since the in-service, this mop-up round is also postponed by the government, which was on 31st of March. Now it is because of Honorable Supreme Court judgment in another matter, wherein All India quota has been postponed, and they are asked to redo the counseling for All India quota, my lords. And therefore, this also is the state government has also postponed the mop-up round. My lords, my request is this, my lords, those 15 seats which have not been filled up, I'll file a memo tomorrow, my lords, because date is not yet been given. And those seats may be notified for in-service candidates, my lords. That is my humble submission, because, my lords, they have, the seats are there. And then mop-up is also postponed. There is no mop-up conducted, and then no date is given, since the All India quota mop-up has to be completed. Therefore, my lords, I request. This is, my lords. My lords, as far as principle is concerned, my lords, there is no doubt, my lords. We cannot. This honorable court cannot take a different view, my lords. But because of this reason, my lords,
you have to move northwards, madam. Huh? You have not told your client to move northwards. By now, SLP should have been filed.
my lords, they have my lords, it is for them, my lords. I only thing this matter is before, my lords. My lord, this matter is before,
where is
my lords.
Where have you said 15 seats and all that? Where are the things?
My lords, yesterday, that is what actually, my lords, I was to be present.
So you
filed
an application for amendment.
Please, my lords.
Counsel for the petitioner
2 days.
submits that the controversy involved in this application is clearly covered by judgment dated 30th March 2022, passed by this court in WP number 6735/2022. However, she prays for adjournment to enable her to move an application for amendment in view of subsequent events. Just after.
December 13. C.H. Vasudeva, 14%.
No, who is appearing 14%?
14% has died.
Right.
Has died.
Why it is listed? What IA? IA for direction. What is it about, Mr.? We don't know what is it about. Can you tell us something about the case? What application for what? This is public interest litigation. About what?
Make one submission.
Public interest litigation about what? Illegal allotment of plots made by BDA. How public interest litigation allotment of
Each category is like.
Oh, one by one, Mr. We are looking at IA number 5 of 18. Who has filed? What is it? Application under Article 226, read with 151. What is your direction prayer? What is it? Allotment of site. What you have to say? IA 5. take action on this. So within how much time? You respond within 1 week, what is there? What can be done? This is 2010, it is pending. WP was filed in year 2010. Where is that? Where have they said? Have they, Mr. Tell us? Have they found? Because we will not say correctly. You tell us. You are an officer. You tell us that whether they have said that he is entitled. What? Where is his name? Where do they say he is entitled? Which is the inquiry report? 5 of 18. IA 5 of 2018. No, but this is how can we allot Mr. Plot to you? We are not BDA. High Court is not BDA. So then you go to them, do whatever. We will, you approach them. So this PIL is pending. Pending. Disposed of. Pending. To PIL. Pending. What has happened in the PIL so far?
PIL, Mr. Vasudev has started the constitutional validity of allotting B category.
Fine, we got it. What has happened in it is pending.
Pending.
What is this inquiry committee, and they are seeking allotment of sites? So like if we usurp the function of BDA and started allotting sites in PIL, then they should better close their office, right? Everybody should come to us BDA. We will become Bangalore Development Authority, right? We don't know. What is it? We will hear this on what is to be on the after vacation, Mr. on merits itself. We will hear what is how a PIL is maintainable, what can be done, who has locus, what all is the inquiry committee, who has, and whether we can give allotment to letter to them in a public interest litigation. All this we will decide. 25th August 2012. Then
There are some applications are filed, therefore it is first place.
PILC, Mr. It is disposed of. You are not even aware. No, Mr. That's fine. I mean, this 25th August 2012, is it disposed of? No. PIL, he's saying it is disposed of on 25th. You want to understand. Mr. We are honestly telling you, normally we go through the file. This file we have not gone through because the record was not sent. That's why we are taking the trouble of asking you. You are not telling us anything. So you are only interested in allotment that the site should be allotted to me. That's it. So we want to understand what is this PIL. Somebody said the petitioner has died. Now we ask you, just a minute. He told us that the public interest litigation is pending. The counsel for BDA says that public interest litigation has been disposed of on 25th of August 2012. So you can understand, right, what confusion is being created. I mean, you are not even aware whether the public interest litigation is pending or not. You are coming in with a myopic view that my allotment letter should be given to you right away by this court before 11:30. That's the. Is it pending? Who is the petitioner? Is it pending? What has happened? What is the order? PIL is pending. You don't know. This is very strange. Examine this. You also examine. You who said PIL is pending? He says it is disposed of. No. You just a minute. No. Yes, this petition which has been disposed of on 25th of August 2012 cannot be kept pending here in perpetuity. We will discuss all interlocutory application with the liberty to everyone to take recourse to the remedy such if it is decided. Tell us, has it been decided? PIA.
I am appealing.
Please go through the record. No, petition is pending or disposed of. Tell us. Disposed of when? What is it? When? When it has been disposed of? What is the date? What is the order by which it has been disposed of? At least you are supposed to know this, right? There is Mr. Nataraj sitting quietly. I mean, unperturbed. We are getting this. They are not. This is not the way to assist us. Learned counsel for the parties are not ready with the matter. They are even able to advise us whether the public interest litigation is pending or not. Let. No submission. You don't know anything. Nobody knows anything about the case. You can't hear like this, right? Who will pass an order? No. We cannot issue this. We are telling you for sure. We cannot issue an order of letter of appointment to like on an interlocutory application which has been made by the council. We won't do it. Nothing enlightening. You don't even know EIL is pending or not. List after ensuing summer vacation. Right.
Connected appeal is not failure. Here I am appearing. That yes, the government has challenged the order.
Mr. Prepare a synopsis on the next date of hearing. Mr. If you want an order from this court, prepare a synopsis. Right? Annex a copy of the order passed by the division bench of this court by which petition has been dismissed. Take up some responsibility to assist the court. That's the only thing. You didn't tell us, right, Mr. They tell us that petition has been disposed of or is pending. One counsel says it's pending, another one says disposed of. This is what it is. You don't even know whether in a pending matter, why we should, if it has been disposed of, why we should enter in interlocutory application, tell us. It has been disposed of. So what is your statement? That is, has it been disposed of or pending PIL? Where it is disposed? What has been done? You don't close. You have read it, no?
The report has been accepted. Some of them
You prepare a synopsis. What is your case, and then tell us, right? Not like this. You cannot shirk away the responsibility when we are asking you to assist us. You cannot say that you only read one paragraph. Give me an allotment letter. You can't say like this, right? We don't know. It is wrongly listed. Then it should go before Chief Justice. Why it has come? By special order it has come. So now, what we are telling you that unfortunately by a special order it is listed before us. Unfortunately for you. So we are being unreasonable to you in asking you to assist us, right? We told you in the beginning that this file was not sent to me at home. I have not gone through it. That's why I'm asking. But this is the stage from where you argue, right? That he's saying it is pending. He's saying it is disposed of. You don't know anything. And you are telling us, all we are doing is please prepare a synopsis. What is your case? How you are entitled to allotment? And tell us under which provision we can issue allotment letter to you. Tell us. Which provision? After vacation. That's all. Be ready. Prepare a synopsis. Tell us what is the order. Where is the order? Along with synopsis, annex the copy of the order passed by the division bench on 25th of August. How this petition, then tell us how this petition can be perpetually kept pending. How is it that henceforth all future allotments of the plot will be monitored by the High Court only? These are few questions. I don't know. That's why I'm asking that how can we accept the allotment in your favor and direct them to allot? We don't. It is the function of BDA to allot. We don't get ready. After vacation, you first prepare a synopsis. Please do it and thereafter mention, because this matter has to come up before this court only. This is special order. So don't worry. So you can always mention whenever you are ready. No. You get ready and take, we will give you a mention. You tell us that I have prepared a scenario and how I am entitled to allotment of a plot, everything. We will do it. We will give you it. It also goes after vacation. 14.
Number 14, Shiv Prakash.
On filing of calculation, who has not filed?
Memo of calculation of payment and the children's education on child education. Now, my humble responsibility, the matter of 2016.
Respondent has to file memo of calculation. When? Why today you have not? Why you have not filed it? That's why we don't refer the matter to mediation, because it's time. This thing you seek time and nothing happens. At the present, how much time? A week's time is granted to enable him to file a memo of calculation.
And we have put all our sincere efforts to resolve this issue. Matter, there is no hopes of resolving this issue. Now, what I put across to my learning.
We will list it for hearing, final hearing. Let the appeal be listed.
My
Final hearing on 31st May.
Because once for all, it's public family, because in between wire media, some figure are given to my friend. If it is given.
No, we are not preventing you from entering into any sort of a compromise. It is open, you talk to him.
I have spoken to him. If he is not prepared for the thing, then I'm very prepared and I do.
Yes, that's why we have given you a date, 31st May, final hearing. What else? 31st May for final hearing. If you want to settle, if it can be settled, fine. Otherwise, you argue on 31st. What is there? He will file you. He will file within 1 week. Within 1 week, he will file the memo.
I appear for the petitioner, my lord. My lord, the petitioner is suffering from jaundice. There is a 41 days delay, my lord. It may be condoned.
Respondent is heard. None for respondent. Allowed, madam. Allowed.
Sir, I appear for petitioner, my lord.
No, why don't you come to court, madam? We are not sitting here to explain it to everything to you. If you can't hear the order, we have passed an order on your application.
Sir, my lord, 2 weeks time may be granted, my lord. I'll appear through court.
Parties report before. Parties present. What happened? BMC report. What happened? Settled.
They have to hand over Melada on the DD and LIC policy to the appellant wife.
Yes, where is DD and yes, madam, where is demand draft? So you are handing over. So what are the terms of the compromise? Have you written down anywhere? No. Where is it?
There are three members. There are three of the mediation. Flag number 4. Flag 4.
Mediation center. Mark the presence. Parties along with their respective counsels are present. Learned counsel for the parties jointly submit that the parties have arrived at the amicable settlement. Subject to what are the conditions? Subject to para 4. Para 4 to 12. Subject to following conditions, paragraph 4 to para 12, right? full stop. In pursuance of the aforesaid judgment, comma, the counsel for respondent has handed over a check of draft for a sum of rupees. Please give it demand draft of rupees 2 lakhs, 6 lakhs to learned counsel for the petitioner, and copy of LIC policy, as well as a copy of LIC policy, the receipt of which is acknowledged by the respondent. Give it.
And by the appellant wife.
Which is acknowledged by the appellant, right? Has been given by the respondent, the receipt of which is acknowledged by the appellant, right? To the aforesaid extent, accordingly, the judgment and decree passed in so and so is modified, in the result appeal is disposed of. Appeals are disposed of, both appeals. Yes, how much was granted before the family court? What was the amount granted to?
Passover.
Weeks. His name, whatever.
Yes, my lord. I appear for the first respondent, and the second respondent's name is missing, my lord. Mr. Amit Deshpande was appearing in the before the single bench, my lord. And he is the.
You will adopt Mr. Amit Deshpande's submission, right?
Yes, my lord. He must have received the instructions. I had
So
not
you are
received
telling us-
instructions. No, I had not received instructions. He must have instructions, my lord. And he was appearing.
Therefore, you are adopting his submissions. See,
he must have
this is
instructions, my lord.
Deshpande's submission.
Unfortunately, I didn't have any instructions because he is contesting. He must have instructions. Name may be shown, my lord. All the other earlier occasions, his name was there.
Application, they made a submission that they were not considering the matter. Hearings are not complete. So that undertaking.
No, the office. His name is not mentioned. No, Mr. Amit Deshpande. Office is directed to. So you have to file a second set, Mr.
Yes, we will.
Learned counsel for the petitioner undertakes to file a second set of petition. Office is directed to reflect the name of Mr. Amit Deshpande as counsel for respondent number 2.
For the vacation.
Why? What is the urgency?
There is a undertaking to the other side not to precipitate the matter. But
Then you should be happy, right? All right. Presence is mark his presence also. Mr. Pillai for respond number 1. Yes. Yes.
Obliged.
Person should be a standing order.
Yes. Mr. Pillai, we have instructed that your presence should be marked as a matter of right.
Obliged, my lords.
Fine. Wherever you are here. Yes. You are for the appellant, we believe. Oh, very good. This intra-court appeal marks it. This intra-court appeal has been filed against order dated 29/11/2020-21 passed by learned single judge in WP number 1919/2021 within bracket LA-BDA. When the matter was taken up today, learned counsel for the appellant clearly submitted that the aforesaid decision of the learned single judge has already been upheld by a division bench of this court. White judgment dated 22nd December 2021 passed in WA number 1363 of 2021 in view of aforesaid submission and for the reasons assigned by a division bench of this court in the aforesaid judgment and with the view to maintain parity. This
Responding number 308. Interim orders have been granted to severe notice.
Mark the counsel for this petitioner. Office objections you have to comply.
And comply with office objection.
Comply.
No, Your Honor.
Well, please comply first, then we will pass an order.
Your Honor, I comply with 1 week, Your Honor, interim order may be passed.
This is very good, right? First grant an interim order. Why we should grant an interim order? Why you should not comply with office objections? We will list it thereafter. Undertakes to comply with office objections within 1 week. Heard on IA 1 of 22, 2 of 22. Dispensation. List on which date you want. By what time will you comply? Then we will pass an interim order, madam.
I will comply within 50 or not tomorrow.
So you said 1 week. Now we are not granting an interim order. See immediately how prompt you have become.
I comply by
See, that's it. Comply undertakes to comply with office objections by tomorrow. List on 6th of April. Keep this list.
Number 23,
Notes appear for the appellants. Notes appellants has filed the synopsis on 24/2/2022 itself, my lords.
Be done. Mr. We will hear it after vacation.
Please, my lords.
After ensuing, the counsel for the applicant submits that he has filed a synopsis on 24/2/2022 list after ensuing summary.
Please, my lords. 24 also, my lords, sir. Some office objection I will rectify it, my lords, immediately after vacation.
It is granted 2 weeks time to enable it to comply with.
Prayer is granted in the writ petition.
I think which case 24. Your prayer is granted in the writ petition.
Not subsequently, my lords, we gave a representation, and that is also rejected. Therefore, we were permitted to amend the writ appeal, and we have, as of now, we have amended the writ appeal.
So endorsement has been dated 15/3/2018 has been quashed, right? No opportunity. How are you aggrieved by this?
Not saying.
That's what the council is saying, that appeal has been allowed. Your writ petition has been allowed.
No, writ petition was allowed, directing me to give a representation. Subsequent pending this writ appeal, we gave a representation. That representation is also rejected.
But you filed a separate writ petition, no?
No,
You have questioned it in a separate writ petition, Mr. How can you amend the writ appeal?
No, the amendment is permitted, my lord. This court permitted, my lords, and we amended the appeal. Lordship may have this matter after vacation, but just, my lord, because Annexure yes is the subsequent endorsement, page 133, and I have not placed the translation.
Subsequent endorsement, you question it in the writ petition. How can you question it in the writ appeal?
Not sir, only as a subsequent development, my lords, we have placed.
No, it's not a subsequent development. Your writ petition was disposed of, directing you to give a representation. That is disposed of. You have to file a separate writ petition.
Yes, my lords, this was the third or fourth round, my lords, writ petition we filed before this court, and this. Not, I will today I'm not in a position to convince. My lordship may apologize, but have this matter on some other day.
Vacation. List after it. Also, statement of objections, Mr. Who has to file, madam. Learned additional government advocate and learned counsel correspondents pray for and are granted. How much time? 3 weeks time to enable them to statement of all. You are also appealing. Right? BDA. All right. Connected matter.
Labour case, the Ramesh P. Kulkarni, C.B. Ravikrishnan, government advocate.
Memo of retirement and stay. Who wants to stay? Memo of.
The 34 years not an application was filed. Or not under the CPC and the prevention of non-corruption alienation of scheduled caste. Expecting a lot, several judgments are held that will not become. What has happened is during the pendency of the petition before the deputy commissioner, he sensitive in favor of the that one. Who got the filed petition? Earlier, owners were not filed. That petition was withdrawn, challenging the very order of the deputy commissioner. Lord, the learned single judge has remanded the matter. This honorable court as well as the Honorable Supreme Court of India not have convenience date. Not for the sake of remand or not. 34 years.
What is the stay you want?
Because the deputy commissioner not remanded the deputy commissioner. Therefore, just have a look at the order.
1 minute. Let him complete.
Page 15.
We are only hearing you on stay because the final hearing will take time.
Yes, I understand.
Yes, you are ready.
That is why my learned friend came to me in the morning. Let's have it next Monday. But this is a case where the remand order was based on the earlier division. SLP is pending.
Right.
And possession has been restored back. We'll file an affidavit.
Next Monday, 11th. Fine. 11th. Mr. Udavala, like senior counsel, Mr. Senior counsel correspondent, prays for adjournment. We case this on 11th of April.
SLP is also listed. The division bench against SLP is pending.
Said 11th.
I'm instructed. The SLP is now listed. I will. He has not challenged the sanction by the government. I have no objection to argue the matter on 11th. But if 11th, my lord, SLP is dismissed or allowed, it depends on. It has got a bearing on.
We don't know. You tell us the date. You said 11th. We fixed 11th. Now you don't want.
No. Just now, my learned friend told me it is on 11th.
12th April.
Whatever.
12th April.
27, government advocate, the adjunct law.
For deletion of R5, R7, 9. He wants to delete somebody.
Here, purchase is not affected by you.
You want to delete. Is the appellant? Whatever. What is it? You are ready?
Everything is not in this matter. If it's further disposed of, we need the Karnataka records and also the earlier revenue records, which will be relevant at the time of hearing this matter. I will secure the record and the matter.
Yeah, all this, everything can't be 11th, 12th, right? Today, what shall we do? And what we will do on 11th, 12th? So
I'll secure the record if required.
So you want You are praying for adjournment. That is understandable. You said you are ready. We asked you, are you ready? So you should have told not ready. Let it go after vacation. What can be done? Huh.
So it's not happened, but the pricing agreed. The matter pertains not actually not Khata, but after 40 years from the Asita. Attending the court, there was a lake.
Mr. What is the direction is only to Tehsildar to implement the order passed by the Special Deputy Commissioner. So that order is not binding on you according to you. What is it?
One state also questioned that order.
Okay.
So that we said, thank you. The commissioner could not have passed that order. That state petition has been dismissed.
So when? So not possible. Place for adjournment to enable him to prepare the case and argue the same list after ensuing summer vacation.
28.
My lord, I appear for petitioner's counsel. I am sorry, appellant's counsel, my lord. These matters, my lord, there are a large number of matters. This is also connected with that. That is regarding a resigning, whether resigning is entitled for pension. There are a large number of matters. My lord,
the main matter, my lord, I appear for the respondent. The main matter is writ appeal 8134 of 2012. This may be linked along with that, my lord. I have no. In fact, my learned senior counsel appears in that case.
8134 of 21.
Of 2012, my lord.
12. Oh.
Yes, my lord.
List for mark the presence, learned senior counsel. For the parties.
I think your lordship can find a time and fix a date, my lord. We are all very anxious. Matter should be heard, my lord, because it is a pension matter.
26th May. 26th May.
As the lordship pleases.
26th. List for analogous hearing along with WA number 8134/2012 on 26th May 2022.
Much obliged, my lord.
29.
It's what the appellate. For what? We don't know. Correspond number 4, list awaiting appearance of learned counsel for the appellant. Hearing of the appeal is deferred. List on 12th April.
Rahul is ready. Government advocate.
Yes.
Presentation dated 14/8/2020. The petitioner is the secretary of the BM. They are running a school.
What is it? Liberty.
64 children, my lord. My lord, petitioner made representation to the respondent on 14/8/2020, stating that, my lord, there is a 2 feet into 70 feet road, my lord, this place, my lord.
No, please read the order. What is it? Para 3.
Para 3, my lord. Applying file a representation.
What is your grievance?
Consider my representation.
What is grievance? Consider means like you cannot give a representation saying that my client should be made president of India and cannot say. So, please tell us what is your grievance in one sentence about which you have given representation. What is it? You are saying that you have told everything else. Close the file first. Close it. Now tell us. Simple words. What are you aggrieved about for which you gave a representation? What
place, Malaka, where the school is there. Malaka,
you are running a school.
Yeah, running the school.
Right. Adjacent to a school, there is a vacant place. What happened?
I have given the representation for the formation of the place, Malaka, the road
Road on the vacant place.
Vacant place, my lord.
You want to form a road.
Go inside the school, my lord.
Ah.
After giving the representation, my lord.
The vacant place belongs to you.
Government. My lord, after giving the representation to the government, my lord, they have started construction, my lord. Can we see Annexure H, my lord? I produced the photograph. They have constructed a compound. I filed a requisition, they will say, since the compound is stopped, my lord.
Right? So what basis you are claiming right over the adjacent land? Like you own a plot, like this is the plot, adjoining plot is there. So you will say it belongs to me also. I will construct a road on the plot. Why?
They are ready, the school is ready to pay whatever the amount the government is, my lord.
It can't be done. You have to, when a writ of mandamus is issued.
Because school, my lord,
it's not in the files. You have read it in the college. When a writ of mandamus is issued.
Because of school, that's why
No. When a writ of mandamus is issued, there should exist a legal right. So that's what we asked you. What is your legal right in respect of a vacant plot? And if you have any right, like easementary right, whatever, you claim it in a suit. We don't know how long.
There is no private party, only government is involved.
That's why the law will not apply to the government, right? So therefore, the law should not apply in case of a government, and you should be given a free run to do whatever you want, without paying, without purchasing. You should own the plot because it belongs to the government. Is the argument?
Pay the amount, whatever the government fixes.
This is not a suit for a specific performance. You have not entered. The government has not entered into an agreement for sale, and this is not a suit for a specific performance that I am ready to pay. Nothing. It's for the government to decide. It's government's property. They will decide if they have to give it to you. They can give it. Our interest.
No, my lord, I said in my petition.
No, we don't want to create any complications by this thing. If you have any nature of right, you should not prejudice it by filing these petitions. Supposing if we say in this petition that you prima facie don't have any right, all avenues would be closed. Do you understand this? Whatever rights, supposing if you are, the school does not mean that license to disobey the law. What sort of an impression you have got? School means what? School means you are not. You will do anything, whatever you feel like. School means what? You are not bound by law. So therefore, you will encroach on government's property. Will construct a road because you are unable to do it. Why seek our permission?
They have considered the compound. That's why we want to stop that.
Okay, supposing if you are the owner of the plot on which school is situated, you are constructing a boundary wall on your premises. So can the government approach us in a writ petition and say that stop this school from constructing the boundary wall in its own property? How? Under which provision? Mandamus, there has to be a pre-existing legal right and corresponding legal duty. You understand that law, right? But you are trying to avoid answering. That doesn't help.
I only asked to consider the representation.
Nothing. We don't want to create any complication. Again, you will come here in second round of litigation that they have rejected the representation. Why?
If they reject the representation, I can challenge before.
No. You challenge before the civil court. First, establish what right do you have to own a property which belongs to the state government. How can you use the property belonging to the state government? Tell us. What is there is something act called Easement Act, right? We don't know what is your case. We don't know whether it's your case that it does not belong to state government but belongs to me.
It belongs to the
and so it belongs to you. Then what is your right? Simple thing. Should we say that there is no right, therefore, or this is what you want? Right? This intra-court appeal has been filed against order dated 24th February 2021, passed by the learned single judge, by which writ petition preferred by the appellant has been disposed of with the liberty to the appellant to take recourse to the dismiss with the liberty, not dispose of, dismiss with the liberty to take recourse to such remedy as may be available to it under the law. Paragraph. Learned counsel for the appellant submits that the appellant runs a school. It is further submitted that adjoining the school, a plot of land is situated which belongs to the state government. It is further submitted that the authorities of the state government are raising construction on the boundary wall on the aforesaid plot, and therefore the state government should be restrained from raising construction on the boundary wall. Raising construction of the boundary wall on the land in question. Paragraph. We have considered the submission made by learned counsel for the appellant and have perused the record. Admittedly, the land in question belongs to the state government. The state government is at liberty to use its property the way in which it likes. Full stop. The appellant has not been able to demonstrate that either it is the owner of the land in question or has any right in respect of land in question. Full stop. Therefore, the prayer for issue of writ of mandamus in the absence of any legal right has rightly not been entertained by the learned single judge. In the result, we do not find any merit in the appeal. The same.
In this case, I'm appearing for the appellant. The appellant land, so the interest of the appellant was a granted land as long back in 1985. And after the death of our father, succession entry was rejected on the ground there was a fraud in the grant. It went up to, I came into before this court division bench.
Yes.
And this honorable division bench of this court has to observe there is no such fraud as such, and again directed to re-examine. Prima facie, this court found there is no fraud. Then the assistant deputy commissioner examined and noticed the fact is there is no fraud. And directed.
What is D, E and F? What is D, E and F?
E and F are the authorities that directed the court. Sorry, I have challenged the document annexure H because during the pendency of again it was granted for the burial ground. When my land is there, holding it is a Gomala land. I already granted. There is no question of Gomala land. It is already a land acquired by me.
Yes.
And this court also affirmed that now, as per annexure E and F, the court directed to enter the record of rights in the name of, because as per the deputy commissioner's order in page 49, 59, deputy commissioner ordered to restore the succession entry that has not been implemented. And therefore, the Tahsildar also directed to the deputy commissioner, nobody has so far implemented. In the meanwhile, very same land is sought to be acquired for the burial ground. That is not permissible because holding it is a Gomala land. It already lost the characteristics of a Gomala land in 1985 itself, and it is our house, it's body land.
Not the owner, right? Yes.
The last right of hearing, the court directed them to government to file objection registered because they have not filed registered before the learned single judge. At the time of admission, the learned single judge dismissed the writ petition. And they took time to file written statement before this court, objection. Now the question is already a granted land in my favor. Can it be now so to be declared as a burial ground for the purpose of burial ground? That too, holding it is a Gomala land.
Yes.
Therefore, my submission, the order of learned single judge is completely learned single misunderstood our case. Learned single judge, she said, my mutation entry is already there. That is not, the question is already granted land. In my favor, already land was granted. Land was granted and only succession, the succession has to be issued. Meanwhile, it ought to be acquired for the purpose of burial ground. When that too holding it as a Gomala land. as per Annexure H. That is not permissible.
It was allotted to him in 1985. Where is Hafte Patra? A document of title. Where is the document of title? Where is the document of title in respect of land question? Where is
This court has already affirmed, madam, this because already after Annexure A and B are the granted land. Grant certificate. Grant certificates. A and B are both grant certificates in my favor, our ancestor favor.
certificate of grant?
Grant certificate of grant in 1985.
They told madam.
This court has examined. Original was called for in the division bench.
The dispute is of which survey number?
Survey number. The survey number is not same. Survey number 72.
What is it?
But the lands do not stand in your name.
No, because of the succession certificate Kotila. This court, because they found there is a fraud in the Arizona grant. Then this court examined and found that prima facie there is no fraud. Thereafter, your lordship will get Annexure C. The division bench's court has held there was no fraud and directed to re-examine. Then the deputy commissioner re-examined and found there is no fraud. It was a granted grant. Therefore, what he said in page 59, he is directed Tahsildar to restore the continuous entries in my name, our name, succession name, in our name.
Not in your name. It is somebody else.
We are all legal representative of deceased Muhammad Ibrahim. We are all deceased legal as of Muhammad Ibrahim. Therefore, court has.
That's why the single judge has said the order, this land never stood in your name.
Sir, sorry, madam. This was. Learned single judge has not read the judgment of the division.
Application for mutation of his name, right?
Never done. The lands never stood in your name. You have not made an application to
sorry,
the lands in your name.
I'm sorry, I'm mistaken. I am not convinced. Your Lordship, the land was granted to us, our mother, our father.
Yes.
It was granted to our father as long back in 1985.
No. If you have succeeded to the property, you should have made necessary application before the revenue authorities to.
No, there is an order. That was the cancel. We started application. It was rejected on the ground. There was a fraud in the original grant itself. That came up to the division bench. This court has noticed there was no fraud.
In the division bench, you are not the party.
I am the party, sir. I am the party, sir. I'm sorry. I am the party. Sorry, I have not. Yeah. Before the division bench. I myself is a party. I myself argue. Jamuna Bhai, these are the sons. Sanawullah, because even now, Jainab is also died. Sanawullah, Sharif, Badrakona, these are the opponents. Petitioners here. Sorry, I have not brought to the notice correctly. We are the same. Our now mother is also dead. Therefore,
Mr. Your grievance is that your name has not been recorded in the revenue records.
Right? Sorry. No, sorry. Our grievance is during the pendency, this land was sought to be allotted to burial ground. During the pendency, which was already granted in our favor, our mother favor, or sorry, our father's deceased father favor, that was already granted. That was already granted, and that's why the deputy commissioner suspected a fraud. Then it come up to division bench. Division bench has noticed prima facie there is no fraud, and on that basis he remanded. Tahsildar directed to re-enter the succession entry. Continue the entries in the computer planning. Therefore, inheritance kata such as computerized planning should be stored at the order of deputy commissioner in page 59. Deputy commissioner directed to enter our name as long back in 2015, pursuant to the demand order by this division bench.
The division bench remanded the matter. What has happened after the remand?
After the remand, D order is passed by the deputy commissioner.
What is the order?
Electing page 59, last operative portion.
In the name of?
The Sharif is deceased, therefore, inheritance kata such as computer money should be effected in 72. measuring 2 acres times the name shall be effected in the joint name of the legal.
After this order was passed by the Deputy Commissioner, have you given any representation?
He directed. He has directed to the Tahsildar. Tahsildar
No,
directed.
did you give any representation?
Sorry,
Producing this order, did you give any representation? That is the single judge has passed an order that you have approached this court without even giving any representation.
I'm sorry. Excuse me, I have not clarified. No, this was an order because the application filed by inheritance Kata Kodiyante, that was the respect. And that was ordered. And it was the Deputy Commissioner himself directed Tahsildar, he has directed Tahsildar. Tahsildar also directed revenue authorities. They are not affected. The Learned Secretary misunderstood my case. My case is that the very same land is now sought to be burial ground. That is our case, which was already granted. Which was already granted.
So the
9.35 acres of land, Gomala land is there. Out of that, 2 acres we have given to burial. We have earmarked for burial.
This all, I mean, this is a title dispute with regard to title. He should establish it in the civil court.
Sorry, Mark.
Cannot get away like this.
No, my lord. This is already because the succession entry is already directed by the Assistant Commissioner, Deputy Commissioner. Now, Deputy Commissioner directed Tahsildar, Assistant Commissioner. In turn, Tahsildar directed to Tahsildar, and Tahsildar directed to effect an entry to the Revenue Inspector. They are not defected. Because my original claim is after death of our father, we filed an application for succession entry.
See, this direction is to deputy, special deputy commissioner. Yes, to follow the procedure, take an action in the correct.
Here, first an order.
Special deputy
Commissioner actually is the order.
He should challenge this.
It is in his favor. This order is in his favor. His entries are not made pursuant to that.
Make a representation. He will make.
On the basis, because now Hiduboli land of mine, ours, our father's land.
He will make an application to Tahsildar. So, madam, in the light of an extra deed, he has to make an application to the Tahsildar, right? We will dispose of with the liberty to make an application.
Sorry, madam. Meanwhile, excuse me, madam. Meanwhile, the very same land is now sought to be regularized in favor of burial ground. But it is
that is disputed by the government. Government says that is not the same land.
Sir, no, madam. I have produced a map also.
No, that disputed question we cannot consider here. They have said it is not the same land. If you want to safeguard your land, you please approach the civil court.
Sir, only one more submission.
Now the Deputy Commissioner has upheld your grant.
Yes, and grant also, yes. And also directed Tahsildar.
On the basis of that, you safeguard your possession and title. If they have passed in some other order, because they have disputed that it is not the same land.
Now we have not filed any objection before the learned judge. Firstly, madam. Now before this court, they also have not filed objection. Now for the first time,
the statement made by the government advocate.
Sir, I only request this. They have not filed. The learned single judge only proceeded. He has not heard the learned single judge.
No, we will record that the government advocate has said that it is not the same land. Your only concern is that it is the same land which is being now diverted for Gomal purpose.
Yes, that's been concern.
Government advocate says it is not the same land. Your problem is solved.
If that observation is made, then I will be safe. Your lordship says that, but our contention is same land.
Government advocate, that statement can be taken. No. It is clear or not? You have made a statement that they are not the same lands. It is not the same land.
Yes, sir. My lord.
Yes.
My lord. May I just know? May I request, my lord? Sorry, my lord.
You give a representation so far as that Kata is concerned. You will give a representation to the Tahsildar. Insofar as your grievance that it is the very same land, we will record the statement of the government advocate that it is not the same land.
Yes. 32, the PP party, the same Nagpur government advocate.
Non-filing of objections.
Please, my lords, on the last date of hearing, the contesting respondent had sought an accommodation to file objections to my stay application.
Fine. So what is wrong about the order?
My lords, our only contention, my lords, is that there was a
You have been granted the liberty to pass afresh after considering his objection.
heard, he has appeared, he has filed objections, we have considered every single contention he has raised.
Where
It's
is that?
lead to a floodgate of such petitions and objections. My lords may permit me to point out my order. My lords,
You read it, what learned single judges
please,
said.
my lords, I have gone through that.
Para 12, 13 and 14.
Please, my lords.
Where is your order under this thing?
Lords, that order, the relevant page, my lords will find it in page number 125, my lords. This is the 28-3 order, which was considered. At the bottom, serial number 3, my lords will find the name of the petitioner.
120.
125 E Krishna. At bottom, Devama is a petitioner, my lords. 37/3 is the survey number, 1 acre 11 guntas. The objections he has filed is in the last but one column on the right-hand side. And the finding given is on the last column, my lords. I'll read it out, my lords, for the convenience of the bench. I'll read the objections so raised by them. Case called on so and so, Shivkumar Ellappa, who is the son of Katedar Devama, appeared on 2/2 and filed objection against the acquisition. In his request, he has sought that they are cultivating grape crops by installing borewells and expanded lakhs of rupees to the same, and hence sought for denotification of the land. Now, my lords, they have heard the objection, undertook spot inspection as well. And then, my lords, the said land is found to be required for industrial area, and suitable price will be fixed for trees, crops standing in the land, and hence the objection is refused and overruled. They've even undertaken a spot inspection. My lords, this is 1 acre 10 guntas in a village where 170 acres have been notified. It will lead to a pockets, a patches of here and there, my lords, opening up. Our only reason for filing this appeal also is we appreciate the fact that we could redo the whole thing once again, my lords. Nevertheless, it will lead to a floodgate of such orders, my lords, after having given a detailed hearing, opportunity of hearing, notice being served on him, he filing objection, we considering every. I'll point out to his objections also he has filed. It is at annexure C, my lords, for free time.
That's fine. Your submission is a detailed speaking order. Fine. That's it. We agree with this, you succeed. Right? That's the only thing.
That's the only contention, my lords. We have considered it and it was considered in all our contention.
All. We have read it. That's why we are asking. That's why we. And thank you. Thank you. Yes. Next.
And the judgment which my lords have already passed, we would like to give
Judgment.
my lords have passed the judgment, my lords.
He says on the facts of this.
Not of much relevance here, my lords, except for one contention as regards the time frame.
The question of time frame, whether if it's a speaking order, you succeed.
Yes.
33. Vijay Kumar.
I think they say.
Whether there are any separate orders or only this one?
21 thing and column. See, what is it? Name is not being shown. Oh, how did you know? You are appearing for. You are appearing for which respondent? What's your name? The office is directed to reflect the name of Mr. H-2 as counsel for respondents. What is to be done? We'll hear it. Not now, day after. Not
Here matter. This is the what they have put.
Is directed to reflect the name. Yes.
Tomorrow,
What do you think this will be allowed to after tomorrow? Then what? This is 2021 matter, right? What is
And in 2020.
we are dealing with 2011 appeals presently. Then, so wait, we are only 12 days away from vacation, right? Do you realize that? What can be done? How this can be heard? This is for preliminary hearing, right? Appeal is admitted for hearing. Fine. Officer is directed to reflect his name. Nothing is not listed today. Preliminary hearing, we have found that this has to be argued. We have admitted your appeal. What else?
The difficulty is that the petitioner will not.
We don't.
The breadwinner in the family dismissed from service. Conviction.
But this is. Yes, we have passed an order. It was
Request, my lord.
preliminary hearing we have admitted. What is
It is only posted for admission today. You have admitted it. If you want an early hearing, please file an application.
Please.
Yes.
the general order?
That's the general order. What is the difference of every and pass the general order?
This is it. This is what is the objection in this land required for that is already stated. Fixed to treat crop standing in the land, hence objection refused. No reason. This intra code item 32. Intra code item number. Mr. D.P. Patil, learned counsel for the appellant, Mr. C.M. Nagbhushan, learned counsel for respondent number 1, learned additional government advocate for respondent number 2. This intra-court appeal has been filed against order dated 11th of December 2020, passed by the learned single judge, by which a writ petition preferred by respondent number 1 has been allowed, and the notification and the impugned order dated impugned order dated 5/3/2018, as well as the notification issued under section 28 within bracket 4 of the KIATB Act dated 15/11/2018, insofar as it pertains to property of respondent number 1 has been quashed, and the full stop. The matter has, the learned single judge is directed has granted the liberty to the KIADB to consider the objection preferred by the respondent number 1 afresh and to pass a speaking order within a period of 3 months. Facts giving rise to filing of this appeal briefly stated are that the appellant is the land measuring 1 acre and and
11.
Yeah, 1 acre and 11 guntas situated where?
Naganayakanahalli village, Chandrapatnam.
No, what is this? Getting survey number 37/3, measuring 1 acre and 11 guntas of Naganayakanahalli village, Chandranarayanpatna, Hubli, Devanahalli Taluk, Bangalore rural district. Case 16. As other lands where required formation of an industrial area, thereupon KIATB appellant Karnataka, and so here is not referred to as the board, issued a notification on 28 within bracket 1 of the Karnataka Industrial Areas Development Act on 6/11/2014. The respondent number 1 thereupon submitted the detailed objections on 2/2/2015. 2/2/2015. the, however, the objections preferred by the appellant. However, the objections preferred by respondent number 1 were rejected, and the notification dated 15/11/2018, 15/11/2018 was issued under section 28 within bracket 4 of the petition. The aforesaid notification was paragraph. The aforesaid notification was challenged by respondent number 1 in a rate petition inter alia on the ground that the objection preferred by the respondent number 1 has been rejected in a mechanical manner. Judge by a judgment dated 11th of December 2020 allowed the writ petition and granted the liberty to pass a fresh notification in respect of land in question after reporting an opportunity of hearing to respondent number 1. Full stop. In the aforesaid factual background, this appeal has been filed. Learned counsel for the appellant submitted that the order passed by the what board? Now passed by the board is a detailed and speaking order, and therefore the learned single judge grossly erred in interfering with the notification. Paragraph we have considered the submission made by learned counsel for the appellant and have perused the record. The relevant extract of the order reads as under. 125 the special land petition. Yeah, and this is the reason. Passed by the special land acquisition officer. Relevant extract of the order passed by the special land acquisition officer of the board reads as under. This is all down to that here up to here, and then this. But objections. Thus, it is evident that no reasons have been assigned by the special land acquisition officer for rejecting the objections preferred by the respondent number 1. The order only contains the conclusion and has been passed in a cryptic and cavalier manner. The learned single judge has therefore rightly held that the order is non-speaking and cryptic. Full stop. The learned single judge, therefore, in the facts of the case, has rightly remitted the matter to the board to conduct an inquiry, to consider the objections preferred by the respondent number 1 and to pass a fresh order. Full stop. The said order is in the order passed by the learned single judge is in consonance with the law laid down by Supreme Court. Law laid down by Supreme Court in what case? SMH. HM Venkatswamy. Where is it? Given citation. Yeah. Mr. Venkatswamy. Last sentence.
Appellant single judges in consonance with the law laid down.
Law laid down by division bench of this court in division court in HM Venkatswamy. HM Venkatswamy was the state of Karnataka. By judgment dated 21/6/2012, passed in WP number 15514 part 2008. Paragraph for the aforementioned reasons. No ground for interference with the interim order is order passed by the learned single judge is made out in the result of the fails and is hereby dismissed.
One short question before going on merits. My lord, I am in annexure A.
That's all right. He's shocked.
Rating list that is down. The person who is put in the rating list is not reported to the duty.
He is seeking for a passover. He is seeking only for a passover.
We don't know. Whenever it comes, it may come after 10 minutes.
Number 35, government advocate, CH-2 Mukanappa.
That we are awaiting what can happen Monday.
It's for adjournment list in the next week. Learned additional government advocate. It's for adjournment list in the next week.
Number 36, the HR showing, the personal is number.
What? Rectification of office objection on IA 1 of 22. Supply them. Learned counsel for respondent number 2 and 3 undertakes to supply copy of IA 1 or 2022 to learned counsel for respondent number 1. And what acknowledgement of having served and no.
Filing memo seeking deletion of respondent number 2 and 3. They were not parties. What happened was, on the last date of occasion,
Fine. Learned counsel. What of?
They were not parties before the court below. They filed an application impleading themselves. That application came to be rejected.
Until now, they need to be heard, right?
You yourself have made them a party.
It was a mistake on our hand that we made them a party because they were. We had to seek leave of the Honorable Court even to make.
Learned counsel for the appellant submits that he has filed a memo seeking leave of.
And filing.
Withdraw. Delete the name of respondent number 2 and 3. 2 and 3. Learned counsel for respondent number 2 and 3 prays for short accommodation to enable him to oppose the prayer. List day after whatever next week. List on 11th April.
Yes. My lord, is this item 36?
Madam,
Lord, is this item 36 or 35? I'm sorry.
Number 36 only, madam. It is ordered and adjourned to 11th. Yes, madam. It is adjourned.
My
to
lord,
11th
not 11th. Can your lordship possibly have it for your lordship was indicating day after? Can your lordship have it on the 6th if possible?
What is the urgency, madam? We are closing for summer vacation. We have 12 days. It's only for deleting the name of respondent number 2 and 3.
My lord, then, my lord, 11th, I'm little busy in the Supreme Court. I was just requesting then it can be 12th or it can be Friday, this Friday, any day. 11th is a little difficult for me. Can it be 6th, 7th, any day?
12th.
12th. Grateful, my lord.
We appear through video. We have to explain it to them. What is the order passed? Yes, what happened?
Purpose, Lord, regarding this of review of the petitioner, Lord. Review of letter.
What is his age?
Lord, 7/3/2020.
Age of your nephew. Age.
He's approximately more than 35 years.
35 years.
Lord,
We hope that he has not committed any offense, right?
But his absence, Lord, is creating a lot of hurdles.
Notice has been issued, right? No.
Notice.
All right. Yes. Issue notice. Madam, yes, accept. What's the SPP? Accept notice on behalf of 1 to 4. Then issue immediate notice to respond number 5.
38. Nagaraj Naidu. 86. Number 39. Mahendra Gowda.
Little later, Mr. Nagar, we'll finish some motion hearing cases. Fine. Yes. We'll take it up. So how much time will you take? 1 hour. Then around 3:30, we'll take it. Yes. Like 2:30.
Ours will be after that.
Huh?
This matter will be after that.
Maybe before, as soon as it finishes.
Number 40. The Vanija MR, government education.
Yes, madam. We have already decided one case, right? 16-4. We have already upheld. See, it fixes a time limit of 6 months. You cannot be struck down. On what ground this you are challenging 16-4? What is the court has they have the legislative competence, right? You don't say that they don't have power to enact section 16-4 of the act. No, don't say. So then what is it? No, it only, you are challenging it as we have gone through your petition. You are challenging it only on the ground of this thing, fixing a time limit of 6 months. So what, I mean, it has to be fixed, right? How it can be arbitrary? And how can we say that, no, it should be 1 year, it should not be 6 months, it should be 9 months or 3 months? We can't question the wisdom, right, of the legislature. And on this ground, a provision cannot be struck down. What do you say, that it should be 9 months? 6 months is arbitrary. What is the challenge? Please tell us.
During this time, we have to file it. But in my case, particularly, what has happened is they couldn't file it because due to flashing school, the work which I was undertaken has been could not complete. I could not file it because the portal was closed. And I filed it again.
That does not render the provision arbitrary, madam, unconstitutional. You could not file it, so fine. That's why you have been denied the benefit of input tax credit. So how that renders the provision bad in law? That's the question. It has come to us because you are challenging the virus of section 16.4. We are trying to understand what ground.
Yes, I can read that. But the other matter is that notices have not been issued to me in time to give a client the reason for all of this. And it has not been considered out. And the bank account has been.
We have had dismissed one case.
16.4 has been upheld earlier.
We have dismissed one petition, right? Dismissed, right? Because we are not getting any grounds on what ground it is ultra virus. He yet to tell us on what grounds it is unconstitutional and ultra virus. What ground, madam?
There is no opportunity for me to explain the delay. And in case there is, they have asked me to pay the taxes and also the interest. That is double tax. Because I have not filed it inside. I have to pay the difference. Already I have paid.
How many it is like that? If you don't pay taxes in time, you have to pay the penalty. So that
And not only me, that the change of that IPC payments, right, has been stopped. The main object of the there should not be double taxation. It should work just like VAT. The VAT has also had the same problems, and it was decided by the Supreme Court also. I don't think the next person who might have, I also will not get it. Yes, okay. It's multiple. Not only need for double taxation, but also multiple taxes. You will find it. And they have issued a notice to the bank to stop payment and change it and section. Are not being issued to me and all the correct is there. Act on 91/2022.
Probably we are not making her clear. If notice has not been given, whatever has not been done, that will not render a statutory provision invalid. If she is agreed, she should take recourse to the remedy under the act. She
can approach the authorities.
How this is ultra wires, we don't know.
No, there is some procedural matter that is there on the part of the authorities.
Karnataka Goods and Services Tax Act. You understand, madam? If you have a grievance, I mean, some procedural lapse, then your remedy is to approach the authorities. Merely because some action has wrongly been taken against you, that will not render the provision invalid.
Even the procedural also, they are not serving. And later, they have attachment proper, attachment back proper. You should notice my bank account, stop paying. Those things have been done only later. There is a preview. All these notices I have received only on the issue. You are actually still
Why? Because section 16(4) is ultra vires, right? Thank you. You cannot tell us what order to pass. We have heard you. Fine. Thank you. Anything else? Anything else? What you have not told us? You said that the state legislature has legislative competence to enact section 16(4). That you told us, right? So what it is arbitrary because notice has not been given to you. We don't know what notice, what if notice is not given, if action is suffers from any procedural infirmity, that will not make section 16(4) ultra vires the constitution, right? It is neither. You have not told us how it is violative of which provision. What is saying arbitrary? We got it. Object is to substitute all tax and levy one tax.
Action of the officer may be not there. Action of the officer may be not the
by issuing the restrictions.
No, it is not defeated by section 16(4) object of the act. We don't know.
It's restriction under section 16(4). Your lordship may kindly see. 16(4). That is putting a restriction. That should be free from.
No restriction, no time limit for filing return. You can file it after 20 years also.
They should have a consideration. Provide that in case. Okay. So if this government on free flow and not to make any penalty or multiple taxes, this section has need to do. In fact, if the restrictions in filing the return have actually been effective at the object of the act.
Where is the provision of the constitution?
They have voted section 64.
To file a return for the month of September following the end of financial year. Therefore, he will be in order to make person eligible for input tax credit. He has to file the return of the 30th of September. What is wrong with this? We don't take no notice. What notice? Yes. Please read, madam. You have not read the provision of which you are striking down.
The register person shall liable to pay register on any tax payable on the supply of goods or services.
No. This is Karnataka Goods and Services Tax Act, right? Karnataka. You are reading central. You have written in the petition Karnataka Goods and Services Tax Act. So section 16(4) reads differently. Page 17, please help us what to do. Where is it? So we will take it up day after tomorrow. Mr. Jeevan J. Niralji, additional government advocate, prays for short adjournment. Enable him to seek instructions and to make a statement list on to seek instructions that's on list on 6th of April.
Chamber 41, the active Municipal order, the heard and understood.
Admitted for hearing. Admitted. Madam, this is only admission. We are admitting. If you want anything, please file an application. Admitted for hearing.
42, the civil Prasad Payer. Sir,
Maintainability of the appeal. Wow, what is it? It is not maintainable. It is admitted for hearing. Record is there. Yes, record is there. Yes.
43, Municipal order.
Admitted for hearing. Record is there, Mr. No. Office is directed to secure the record.
44, the candidate.
Record is there, right? Admitted for you.
45, the Naveen Kumar.
What is there?
Records will be called.
Called. Office is directed to secure the record of the family.
Number 46, the Narayan Reddy HS, the Mohan Kumar.
Record.
47, Srimati Ratna Shrivaman, Sri Santosh Gogi. 48, Sri Ravi Shankar CS. 57 poem.
What is it?
One of the respondents was that they were all right with the decision, subject to the fact that it should not operate as a precedent in other cases. That is what the contention is. I have nothing to say.
That is not the only contention, right? That we have.
It needs to be heard, right? What is that?
It has to be heard.
All right, appeal is admitted for you.
We
What is that?
have admitted that several matters are pending. Where the bank matter.
Oh, we will give a date. Please give a date on this. 30th May, 20 list for hearing on 30th May.
In the meanwhile, I have undertaken that I will not precipitate matters. The bank is precipitating matters. Let them not do that.
They don't.
Writing to my tenants.
Yeah.
I have done
entire amount.
You have received the entire
Entire
amount,
OTS amount is received by you.
Whatever the earlier amount accept agree has been received. I'm not.
Don't precipitate.
Don't precipitate.
Because the bank not
After hearing learned counsel for the parties, they
Sorry,
have
that's
directed
right.
that parties shall maintain status quo with regard to subject matter of this appeal.
Till next year.
Not till next date, okay. List on 30th May for hearing.
Engineering, number 50. 49, Sri Manmohan PS, Sri George Joseph.
Oh. You heard? Just wait. Just wait. No, this is preliminary grade.
This is the group. This is the last admission.
Last day. Yep.
Defined not the trial court is granted not a blanket examination not begin. But that not respondent not is
Where is it? You have given synopsis. We are hearing you only on admission day, right? Not this week final. What is it? Synopsis, Mr. There, no?
30th of March.
30th March.
Yeah.
Yes.
Benefit not is the Bank of Dubai. But it is a case that not the few of the defendants, not other than me, would have obtained not letter of credit facility not from the bank, and not that money is not paid by the original defendants. Insofar as I am concerned, not I am a company which not is incorporated in India. So insofar as I am concerned, not admittedly there is no loan transaction, nor am I a guarantor for the loan transaction. Now, Lord, the respondents Lord have already initiated proceedings before the court at Dubai, Lord, seeking for recovery Lord of this amount, but from Lord the borrowers. There is a defendant number 1, 2, and 4. And Lord, that suit was Lord decreed during pendency of this suit before the trial court. Lord, they suppress the fact that earlier Lord they had filed another suit before the court at Dubai, and that suit Lord the application for attachment etc. was rejected. That Lord was not brought to the notice of the trial court. But trial court Lord does not notice the fact that Lord, insofar as I am concerned, I am neither a party to the agreement, nor am I a borrower, nor have I signed any of Lord these documents. The only case as against me, Lord, is that the funds are transferred Lord by the defendants to me, the Indian company. And therefore, they say I should not deal with any of my properties or issue any loan or do anything. Not to kindly not permit me to take notes of the plain government.
Funds are transferred by whom? Right? Funds are transferred.
Funds not are transferred by defendant number 2. Lord. Why company? That's different number 4. I'm sorry. 4. Can I just perceive not so kindly turn to not the plain government at page 86 not the appeal.
But what is the order? You have been restrained from alienation, right?
No, Lord. The order, Lord, is it's a blanket order. Lord should turn to the operative portion of the order at page 66. The order says not that
transferring, alienating, or otherwise dealing with creating third party
or extending any loan or guarantee or encumbering any manner any property and assets in any manner whatsoever during subsistence of personal guarantee. But personal guarantee I have not issued. Dated so and so as long as any monies are owing under the credit facility dated 8/5/2017 to plaintiff amended and enhanced wide extension letters.
Why do you say that you are not being permitted to operate the bank account?
No, Lord, by virtue of this, Lord, it's a blanket order, Lord. I cannot not deal with my assets also, encumbering in any manner, or Lord, loan guarantees or doing anything. Lord. It's a complete Lord closure, Lord. I cannot do anything.
How? You have only been restrained. It's all right. Go ahead. Yes.
But what this order says, Lord, not to kindly see, Lord, creating, disposing of, or creating any third-party interest or extending any loan or guarantee or encumbering any manner, any property and assets in any manner.
Financial institution.
Is not.
You are a financial institution or what?
No. I'm a company. Not. I'm a company.
Extending any loan or guarantee. All right. Please go ahead.
Please, can I request not to kindly turn to page 85?
85.
Para 37, if you lost me, permit me. Upon occurrence of default, you also got it.
Yes.
Upon occurrence of default, plaintiff has also conducted inquiries into the affairs of defendant number 3 company by examining its financial statements filed with the Ministry of Corporate Affairs for financial years 2017-18 and 18-19. It is pertinent to note that perusal of the balance sheet filed by defendant number 3 for financial year ending so and so, the following suspicious action become questionable. An advance from defendant number 4 to defendant number 3 of an amount of rupees so and so. However, the purpose of such advance was not specified. A transaction of rupees 21 crores, 21 lakhs so and so, which was received by defendant number 3 from defendant number 4 purportedly for a works contract. Then param 38 refers to this money that are transferred. Then kindly see para 39.
How much amount has been transferred to you?
But the total amount transferred to me, what can I just pass on? Page
57.
That is 79 crores.
79.
79 crores, 39 lakhs, 49 crores.
Yes, but he is neither a borrower nor a guarantor, Mr. Naganan. So perhaps they should secure this much of amount in your favor, 79 crores, whatever. Subject to that, some arrangement can be made.
There is direct evidence to show, but there is also this retail company for your lordships now. It's owned and controlled by the same 2 people who promoted those 2 companies. The submission that we made was that this is a fraudulent company, which is with the corporate way. All its assets are the assets of the main 2 culprits who have borrowed the money. That is the submission we made. Whenever we see issue of the court, it is not some company. We place this material to the Ministry of Corporate Affairs balance sheet. So ultimately, if the court comes to the conclusion that they are indeed a fraudulent company, then not stipulating not the Supreme Court of data, that the corporate will be lifted and all their properties can be procedural. Not only 79 crores, 79 crores is only to show that much money has actually been transferred.
Good.
Yes.
Can I just not to permit to just not
yes.
memo not a few documents.
After 79.
The document was not placed before the trial.
Some statement has been produced.
All right, but when do you want? PM and one learned counsel for the appellant. Mr. S.S. Nagarandan, senior counsel for respondent number one. Respondent. Learned counsel for the appellant during the course of submissions has passed on a memo containing documents in view of a aforesaid learned senior counsel for respondent place for short accommodation to enable him to seek instructions. List on which next week, which date? 11th April.
13th, some difficulty.
13th April.
Number 4. Madhukar Nadi.
Government advocate has clarified that.
Yes. What clarified?
Warrant has been in the third respondent.
No, warrant has been issued
To the third respondent.
What
That's why
happened?
the matter has been passed to the.
What has happened to the warrant?
What happened? Yes, madam.
Why that government advocate always appearing online only? Got some personal problem.
What happened?
Sir, Tejesh, sir.
Yes, madam. This we had directed. See, response number 3 had not appeared on 24th March and 28th March. So we directed that his presence be secured by available warrant. What happened? He said that he will seek instructions and sort a password. This is password, madam. You call him. Not responding. Calling.
Camera. Yes.
Yes, close the camera. Yes. There. So maybe waiting for your call. Please go out and. Yes. What your daughter or son is in the custody of husband? Huh? How old is your son or daughter? Son, 4.5 years old.
It's a remote, he's in a remote area.
No, where is this respond number 3? Your near Basu. Okay. So what is he doing? What is it? Respond number 3.
Respondent number engineer. But from home.
No, but he is not represented by any council.
Represented.
Not appearing. Not appearing. Yes, madam, what happened? Not responding. It's already turned off the camera. What is this, mister? You make us wait. What is this?
Sorry, my lord. I just went to inquire, my lord. My lord, in this.
I mean, your colleague was required to go out to make a call, and thereafter, I mean, what is this?
No, my lord. I just went to inquire from my office, my lord. My lord, the commissioner. My lord, they have not received the any available warrant from this court, my lord. That is what they say, my lord.
So maybe we should.
They have not received any communication from this court, my lord, for executing bailable order, my lord.
Later.
What's happened to the available warrant issued by us? What happened? Is it not forwarded?
Okay. So there is a lapse on the part of the office, right? Today. In compliance of market figures, in compliance of the order passed on 28/3/2022, the office has dispatched a warrant on available warrant on 4th of April 2022. Of the like it is dispatched on 29/3.
My lord, the commissioner office has not
based on 29th March 2022. The house like below. Learned additional government advocate submits that the aforesaid available warrant has not been issued. So you, Mr. You asked to.
My lord, I have informed the commissioner of police to verify it, my lord, and get it executed, my lord.
I mean, now that warrant is of no use, right?
Please.
So office is directed to reissue the available warrant and available warrant to Commissioner of Police for effecting service on respondent number 3 for his appearance before this court on 11th April.
Please, my lord.
2000. Mr. You do it.
Please, my lord, I'll inform the commissioner of police today itself and see that it is executed.
17.
Airport has ordered 2,000.
So, when you are claiming maintenance, what is the respondent doing?
Data entry operator at Victoria Hospital.
Right, Matt?
Security agency. The security agency is doing work in the Victoria Hospital and getting the license and
Security agency.
Security service provider.
You know what is his post, Matt?
It is data entry.
So then why you should say no? That's what he said. Data entry.
That in Victoria Hospital, this is out-resource person. Out-resource person from agency.
Is presently working in Victoria Hospital.
That's a data entry operating, and we're getting the salary of 11,257. I have the salary certificate also.
11,000.
11,257 and salary taking home is 10,883.
And you have taken some like EMI. You are paying 5,000 rupees loan. Loan you have not taken. No. We thought you should have advised your client to pay EMI of 6,000 rupees. No.
I'm making fair submission.
Fair. Always fair submission you have to make. So 11,057 is the salary.
11,057 is the salary certificate, Mala. He is getting his monthly in a statement passbook, Mala, 10,883.
10,830. 883. So all right. So what is so there's no child born from this marriage?
That is my contention, because marriage in the year of 2008. Marriage in the year of
Fine. No. We are asking how many dependents on you. You are the only this thing, right? So, fine.
Parents are there. Parents are there. Father and mother.
So Mr. 10,833 divided by 4,000 rupees at least. 3,720. 1,720. 2,800. So you have to pay 2,800 as maintenance.
Contention, as per 125, class 4. Why herself she has deserted the respondent.
That we will decide.
That is, my lord, in the trial court is very clearly, my lord, last sheet use the outer sheet of the trial court for a moment. They have clearly mentioned that, my lord, she don't want to decide with the respondent in Tara.
There may be a justifiable cause, right? Who knows?
No, kindly, your lordship, there is the judgment, your lordship.
You want to live with her or you don't want to live with her?
She herself, she is making subject. I am the husband.
You are the husband. You want to live with her or you don't want to live
I am
with her?
ready to live with her. I am giving the statement. I am ready to live with her.
Then why are you saying that she has deserted?
Also happened, but but she don't want, she given before herself. I don't want to live with him. The same quotation was highlighted by the Honorable Trial Court in para 10 of the judgment. Your Lordship, we kindly reduce that para 10, Your Lordship, for a moment. Para 10, after the 5 days, during the course of cross-examination of the petitioner, she admits that she came to the house of the respondent only for customary ceremony. Those who have denied that after 4 days, she has returned to her parents' house. She failed to depose that how many days she has stayed in the house of the respondent.
That is, madam, that is the issue in appeal, right? She has challenged it. This finding is under challenge, right? It's not final.
She's not.
So, I mean, right now she's your wife. You have to make payment of it. How can you get away by relying on para 10? You won't pay anything. Not possible.
They are relying only the memo matter. They are relying only the memo matter, that is 28/7/2014. I have given memo matter. In that he specifically mentioned that matter. She has told that she has a relationship with the other person she want to marry. The same, but they are not taking that contention matter. They in para, your Lordship may para 21 of the this one matter appeal. Your Lordship may para 21 of their own pleading matter. Their own pleading, they submitted that matter. The contents of the memo was not considered at all by the Honorable Trial Court matter. Their contention matter. That is on 28th, and the petitioner is respondent is also ready to take the divorce matter, but they are asking the alimony matter. She is not ready to live with him matter. She is not ready to live with him. Where is the question of giving the alimony matter? That is only the matter. Then here, matter 125/4, when she is herself, she has neglected reside with the husband, then she is not entitled for the maintenance.
This is under 24, right, madam? Application. Fine. That is the issue to be decided in appeal. That is the appeal filed by her.
In the year of 2019.
Heard on IA number 5. Heard on IA number 1 of 20 and application seeking grant of maintenance. Learned counsel for the appellant submitted that the appellant is the legally wedded wife of the respondent and is entitled to maintenance. However, it is also it is also submitted that the respondent is employed as a data entry operator in Victoria Hospital, full stop, on the Victoria Hospital, and is drawing a monthly salary of ₹11,057. On the other hand, learned counsel for respondent has fairly submitted that the take home salary of the respondent is ₹10,883. It is also submitted that respondent is required to take care of his old and infirm parents. It is also it is also submitted that since the appellant has deserted the respondent, therefore the appellant is not entitled. Appellant is not entitled to claim the maintenance. Paragraph, we have considered the submission made on both sides and as perused the record. Admittedly, the appellant is employed as a data entry operator in Victoria Hospital and is drawing the monthly salary of ₹10,883, taking into account the fact that the appellant is the wife of the respondent, and the issue whether or not the appellant has deserted the respondent is yet to be adjudicated in this appeal, we direct that the respondent shall pay a sum of ₹2,800 per month by way of maintenance to the appellant from the date of this application. The arrears of maintenance shall be paid to the appellant on or before 30th June 2020. Accordingly, IA 1 of 20 is 30th June, you have to pay the amount, whole arrears, etc. So for that purpose, we have said up to 30th June, you pay the arrears of maintenance. Right? We have given you 2 months time.
Application in 2020.
What to do? Yes. Suddenly she. Your wife realized the importance of money. She realized that without money she can't live. That's why. Right. Oh. No, no. Date of. No. Yes. Oh. Yes. This is to be heard, right? Huh?
Before going to the merits of the case.
What is it? It is listed for preliminary hearing. What preliminary hearing?
Before that, I annexed A, page 46, 48. The petitioner's name is found. Definitely, yes. Told 99.40584%. Page 49.
No, it says that your grievance has already been considered like rejected by coordinate benches.
Not like Parmesh, another person. Number 34.
Two judgments which were referred to.
No, that is not.
That has been affirmed by the division bench on 16/3/2022. In two written appeals, 1221 of 2018.
Not on merits.
1221.
Parmesh.
1221 of 2018 and writ appeal 618 of 2018. Disposal dated 16/3/2022.
That is not the question, my lord. I am putting before argument, before going.
1 minute. 1 minute. We will hear you. Don't worry. But we want to understand the facts. You are straightway taking us to page 48. So we want to know what is the petition pursuant to selection process and list of final case.
Next, page
1 minute. Let him answer. The petitioner did not figure in final select case. Their representation key answer. Wrong. Therefore, called in question adopted by PCI.
Now that order passed by the division bench, not released.
Yes.
49, page 49. This is annexure A, is the revised.
So how do you challenge this finding recorded by learned single judge in para 7? Come to page 20.
Before going on that merits of the case, my submission is annexure A. One Parmesha is put in same marks he obtained. He was put in waiting list. He was not reported to the duty now. So the next option is to give it to the petitioner. That is before going on to the merits of the case. My submission is annexure A, page 33, page 49, serial number 33, 34. My name is found in 33. The one Parmesh name is found in 34. 34, the name found in 34 was put in waiting list at annexure R1, page 183.
Have you raised this ground in the petition?
That is what now this was raised in the. That is why he has produced the annexure. Now he has not reported to the duty. Next option is to be given.
Have you raised that ground in the petition?
No, that is why I am filing the application to consider that option. So I have served the copy to the.
File it there, whatever.
I will file it to the.
learned counsel from the applicant praised for adjournment in order to enable him to file a memorandum of documents list of this that case one.
Ma'am, Mr.
38.
What of the Sriram? Sriram, what of
But the petitioner, even when the matter is called in second round, awaiting appearance of learned counsel for the petitioner, hearing of the petition is deferred list after ensuing summary.
39.
I appear for respondent number 6.
Yes.
This item not length. At which stage not your lordship said that the other side had argued on the merits. Your lordship said kind enough to give me an opportunity to make my submissions on the merits. Make the task, my task easier, not a prepared submissions.
No, our task also is yes.
I find not that this system which your lordships have introduced is a great boon for lawyers. Because it helps us to sit down, apply our mind to what is really the crux of the issue and present it before the court in as precise and concise a manner as possible. Otherwise, we have a tendency to sort of go on rambling about.
Yes.
So, I find one word compilation is called written submission.
Where is it? No, written submission.
Now being filed.
Yes.
But just to recapitulate, in some days, not since the lordships have had occasion to hear it. The writ petitioner, not in this case, that is WP 834, is a successful candidate in an election for the president of the town municipal council at Malu. Now, just before the election, 4 persons who had a right to vote at the meeting or election of the president, they filed a writ petition. And in the writ petition, my lord, an interim order was granted by the very single judge in December, just before the election, by which, my lord, it was directed that these persons, though they were nominated persons, they are entitled and eligible to vote. That is the interim order. Subsequently, my lord, the election was held, and these 4 persons, my lord, did participate and cast a vote. And this petitioner 834 became elected. Now, Lord, in the writ petition that was originally filed, the constitutional validity was not challenged because it was not necessary. And I made, Lord, that is this petitioner in WP 834 filed an application for impeachment. That was, Lord, pending. Meanwhile, my lord, the petition 834 of 22 was filed after the election was over. If you lordship to take the petition, the players will not in the petition. Page 19, 19, WP 834. We sought a declaration that the proviso to section 11(1)(b) is ultra virus, or alternative to read it down. The proviso not provides as to who can participate in the election of the president. Then, Lord, Article 243R is also a question because it indicates that there is a restriction. Then, Lord, whether for the post of president and vice president, such a restriction would result in Article 14 violation, or should it be saved by interpretation
so that everybody who is a member is entitled to cast his election vote. These are the main beliefs that were sought. Not in the meanwhile, my lord, I made an application and sought permission to withdraw my impleadment application or in the other petition. That was allowed by the learned judge. Meanwhile, my lord, the learned judge heard the petition and my lord passed an order against which not appeals are preferred. Those are also before the lordship. Now, my lord, kindly take the written submissions that I have now filed. There is a list of dates there now. The first one is election date. The second is 22/12/21, calendar of events. And on 28/12/21 is the petition, not which I mentioned, 24,308. 29/12 was the order not passed by the learned judge. Then 30/11 election was actually held. On 10th January, we filed an application for impleadment. And subsequently, present writ petition was filed. In this writ petition, we have made a submission also that I had filed an application and I am seeking permission to withdraw it. That statement also been made in this. Then, the IA for impleadment filed by the petitioner in WQ was withdrawn subsequently. The memo for withdrawal was filed in that court, and my application was dismissed. Then, when the writ petition was heard and disposed of, an interim order that been granted earlier was extended. That's how the matter came up before your lordship. This writ petition, since they have questioned the constitutional validity, it is before your lordship's on the merits of the case, the submission that I made to Lord is that there is a distinction. That's what I pointed out in the first submission. The election of a chairperson of the municipality, the election to the chairperson, there is a distinction in the act and in the rules between what is a meeting of the council, what is an election of the council. Section 11, if the lordship please permit me to read that. So the interpretation of section 11 falls for a lordship in consideration now. So the Municipalities Act, Karnataka Municipalities Act.
There is no other password matter, right?
Section 11 is Constitution of Municipal Council. The Municipal Council shall consist of the composition is given them not depending on municipal area, etc. Then B, we are not concerned with B. Not more than 5 persons nominated by the government from amongst the residents of the municipal area and who are persons having special knowledge and experience in municipal administration or matters relating to health, town planning or education, or social workers, members of the House of the People, members of the Legislative Assembly, members of the Council of States Legislative Council. Provided that persons referred to in clause B shall not have a right to vote in the meetings of the municipal council. Now, my lord, my learned friend, while arguing, had some very caustic remarks about who social workers are and how they can be appointed. And that seems to be at variance with what the Constitution says. I'm not going to join issue on any of those things. The law remains as it is. It provides for nomination. And the restriction of in B of those persons nominated under B is contained in the proviso as meetings. Then, my lord, the question that arises for kind consideration now is whether election of the president, is it at a meeting or is it something which precedes any meeting? Till the election of the president is done, there is no council meeting. That is a submission which will be. Now, to the same extent, if your lordship should please turn to my note of submissions, page 3, I have extracted article 243R. What is the composition? Persons elected, then nominated. And it also says
The proviso is identical, no right to vote. In furtherance of the enabling provision, my lord, in 243R, as your lordships, my lord, saw, 243 sub-article 2, it provides legislature of the state may by law. So in exercise of that power, the Municipalities Act, my lord, has been enacted. Also, my lord, the Karnataka municipalities, President, Vice President election rules of 1965 have to be read to understand, my lord, the correct interpretation of these provisions. The lordship may please say that you will not be a copy of the information.
Oh, yes.
Lordship could not please take the rules of 1965. Rule 3. Appointment of the date of meeting. The election of president and vice president shall be held in the meeting fixed by the election officer, and he shall thereupon send to every councillor notice of the date so fixed, not less than 7 days prior to the date of the meeting. This was harped on by the other side to say that the election is also at a meeting. Then, my lord, nomination, filing, etc. And you then go to Rule 8. Sub-Rule 3 of 8. Vote shall be taken by show of hands. The councillors voting for and against any candidate shall record their votes in the proceeding registered by signing it or by fixing the rectum impression in the appropriate column. Any member present at the meeting may refrain from voting if he so chooses. After voting by all councillors present and wishing to vote, the election officer shall declare that the candidate to whom the highest number of valid votes have been given to have been duly elected. Then, my lord, there are reservation provisions which are not so relevant. Kindly notice Article 243R of the Constitution. A sub-article 2, which your lordship notice, is out to that. Provided that persons referred to in paragraph 1 shall not have the right to vote in the meetings of the municipalities. That proviso, my lord, 1, small Roman 1 is there, that applies to persons having special knowledge or experience in municipal administration. So the law enables two types of legislation that could be done. Constitution envisages that. One, you could have a legislation which provides for the manner of election, which could take note of the restriction on voting at meetings of one category of persons only, that is special knowledge experience. Then the subclause B is another enabling power. That enabling power is the manner of election of the chairperson of a municipality. So these are two distinct and different things. It is an exercise of this power that these rules are now being framed. Your lordship should now look at the rule 3. It talks of a 7-day notice. Just now, your lordship are pleased to peruse that. I must draw your lordship's kind attention to a few provisions of the Act, which also have some bearing on the interpretation. And in Lord see section 2, subsection 6. Councillor means any person who is legally a member of a municipal council. So a nominated member is also a member of the municipal council. Then there are section 42. My learned friend has already read it. Just drawing attention to it once again. 42, subsection 2. Subject to the provisions of subsection 2A, councillors shall, at the first meeting of the municipal council, after the general election, and at a subsequent meeting held immediately before the expiry of the term of office of President and Vice President, choose 2 members from amongst elected councillors to be respectively President, Vice President, and so often as there is casual vacancy in the office of President, Vice President, shall choose another member from amongst elected councillors to be President. So, election, the person eligible to be elected to these offices is an elected councillor, not a nominated councillor. But it does refer to meetings. And not section 47. Normal act provision relating to meeting when it should be held. Can this be relatable to an election meeting is a question. The municipal council shall ordinarily hold at least 1 meeting in every month for the transaction of business, which shall be called an ordinary general meeting. Then the president may, whenever he thinks fit, and shall upon written request of not less than 1/3 of the total number of councillors, fix a date not more than 15 days, etc. Then 48. 7 clear days notice of an ordinary general meeting and 3 clear days notice, or in case of urgency, notice of such shorter period as is reasonable, of a specific general meeting, specifying the time and place at which such meeting is to be held, business to be transacted, to be given by the chief officer or the municipal commissioner to the councillors posted up at the municipal office. The said notice shall include any motion or proposition which a councillor shall have given written notice not less than 10 days previous to the meeting of his intention to bring forth thereat, and in the case of a special general meeting, any motion or proposition mentioned in any written request made for such meeting. Place of meetings. So, what becomes apparent to Lord from the reading of this is that they make a distinction between an election meeting and a normal meeting. One more provision, and that's all that I want to refer in the Act. Can we see in section 42 itself? There's a special provision for a no confidence motion and the procedure for it in subsection 9 of 42. Every president and every vice president of a municipal council shall forthwith be deemed to have vacated his office if a resolution expressing want of confidence in him is passed by a majority of the total number of councillors having voting right, not mark that, and by a majority of not less than 2/3 of the councillors having voting right present and voting at a special general meeting convened for the purpose. So, when it comes to removal also, they form a separate category of what should be the majority and how that majority has to be constituted. The nominated members are not to be taken into consideration for this. So the no confidence motion should be relatable to those who are elected members only. Whereas when it comes to election, such a provision is not made specifically. But the argument is by inference that the proviso says that nominated members cannot vote at a meeting, and this is a meeting, and therefore that bar should apply. That's the inference that is sought to be drawn. In my respectful service, that is not the correct inference. I am fortified by some authorities in that regard. I may now go back to the note law. I have more or less not set out the same provisions in my notes. I don't propose to not trouble your lordship with reading it once again. The propositions is councillor is very wide. The third proposition is at page 6 of my note, that the meeting is distinct from an election meeting. As set out in section 47 also. Then one more section, 51, I put it on page 8 of my note. Who shall preside over the meeting? The president or in his absence, the vice president shall preside at every meeting of the municipal council. And he will have asking vote, etc. Now, here also is referring to a meeting. So not, if the president is not yet been elected and his election has to take place, then how would we interpret section 51 as a question that will arise? Because at that meeting, if it is a meeting of election, this provision will not apply because there is no presiding officer. After any meeting, there has to be a chairman, there is a person who presides. The question of election of that chairman himself is an issue in a case. It is just an election, it is not a meeting. That is our submission. Because this 51 is talking about an additional casting vote to the presiding officer or a president of the meeting. And that is not possible because election is not yet taking place. Now, one other proposition is that when a word is used in one section or one part of the statute, it may not have to be interpreted in exactly the same way throughout the section. It takes color from the context in which it is used. Merely because they called an election meeting, is it a meeting as contemplated in the Act? It is a question which will arise for consideration, and I'll cite one or two authorities for that. Not a somewhat similar issue has arisen before the Allahabad High Court, not a division bench, a full bench of the Allahabad High Court. I have not filed that judgment in my compilation. The Lordship could kindly not take my compiled list of authorities which I filed. It is a judgment number 10, dated 28 February 22, has 12 judgments. List of authorities. In the page 120, but kindly go to page 124. This also related not to an election to the municipal council. At 124, paragraph 16. The Council for Respondents submitted that an election is not a meeting of the municipality, and hence the proviso to Article 243 R2 has no application. He submitted that the word meeting has to be construed in the light of section 86 to 88 of the Union Municipalities Act. Hence, a meeting is a proceeding which takes place only after the municipality is constituted. An election is a process prior to the constitution of municipality, and hence it cannot be regarded as a meeting of the municipality. Then another opposite side argument is noticed. Number of judgments are taken note of. Then what paragraph 41. In state of Bihar, this is not at page 127. This is Charushila Dasi. Supreme Court observed, it is now well settled that there is a general presumption that the legislature does not intend to exceed its jurisdiction. It is a sound principle of construction that the act of a sovereign legislature should, if possible, receive such an interpretation as will make it operative, not inoperative. In view of the above, we are of the opinion that the word meeting in the proviso to Article 243 R2 should not be interpreted to include an election. Otherwise, section 54(1) would become unconstitutional. We should take an interpretation which sustains the constitutional validity of section 54(1) of the Municipalities Act in preference to an interpretation which invalidates statutory provision. Hence, in our opinion, nominated members can also vote in the election for vice president. For the reasons given above, no merit in the petition. There is a reason why, my lord, I have included an alternate prayer in my petition, that by a process of interpretation, it could be read down to this same meaning. Now, my lord, may I just cite a few authorities, my lord, in the same compilation. They are all well settled propositions, my lord. Only read one or two lines, that's all. First judgment, is courts not to add or subtract words. The first judgment, Lord, the relevant portions at page 9. Continuation of para 13. 13 begins at page 8, bottom. The second principle of interpretation are that the court must proceed on the assumption that legislature did not make a mistake, that it did what it intended to do. The court must, as far as possible, adopt a construction which will carry out the obvious intention of the legislature. Undoubtedly, if there is a defect or omission, the words used by the legislature court would not go to its aid to correct up, make up the deficiency. Court would not add words to a statute or read words into it which are not there, especially when literal reading produces an intelligible result. The court cannot aid the legislation's defective case. Then, my lord. The reason why we are citing this, Lord, in section 42, your lordship just now saw, the voting members is what is referred to there. Whereas, if you see the entire scheme of the Act, it becomes very clear that a regular meeting is different from what is an election. So, by using the same word everywhere, was that the intention is the question. Then, my lord, the courts not to assume legislature has made a mistake by interpreting statutes. But if you please turn to, my lord, page 20. Paragraph number 27 and 28. 29. In view of the above, it becomes crystal clear that under the garb of interpreting the provision, court does not have the power to add or subtract a single word, as it would not amount to interpretation but legislation. Then, my lord, the other side has cited a few decisions and distinguished them. These two judgments are for that purpose. That both the judgments do not lay down that the ratio of a decision will take color from the facts that were present in it. And those are, my lord, kindly turn to page 39, the relevant portion. Not para numbers, not are 31 onwards. In page, that is serial page 39, para 31. At this juncture, we think it condign to refer to certain authorities which laid down the principle for understanding the ratio destiny of judgment. Such a deliberation we are disposed to think is necessary, as we notice that contentions raised that certain observations in some paragraphs in SPP have been relied upon to build the edifice, that latter judgments are not referred to them. Then, my lord, the detailed discussion is at page 41. There's an extract, my lord, from Home Mittal's case, para 39. Last sentence in the extract. Judgments are not to be construed as statutes in that same paragraph. The ratio defined of a judgment is not to be discerned from stray word or phrase read in isolation. The same extent, my lord, is the one more judgment, one sentence in page 65. Lord, these are well settled propositions. I don't want to take trouble reading it. Paragraph 20 is relevant. What is it that the court actually looked into, and what were the facts? What were the findings? That has to be seen. Next two judgments also not to the same effect. Precedents must be read in the context in which they are made. Relevant portion was at page 82, paragraph 10. To 13. Now we cannot read one sentence in a judgment and come to any conclusion. The Constitution bench in Padma Sundar's case, page 92. The famous statement has been reiterated in several judgments thereafter. Court should not place reliance on decisions without discussing how the factual situation fits in. Lord, deal with the question as to whether the votes of nominated members can be taken for no confidence motion, just to give a lordships an idea now of how the courts interpreted that. Page 97, the lordships notice the language. Up 130, I'm told, but I can.
All right. Continue.
What is happening today not because the then single judge in another litigation, they filed an application to give effect to the judgment given by him. And that is set on at 230. I filed an application in this petition now to say that.
Yes,
Madam Lord, I request the other side not to proceed it since the matter is being heard now.
Oh, yes, at 2:30. Okay. Yes, we are hearing the case now. You can tell the single judge, right?
ಈಸಿಗೆ
ಉಪ್ರತಿ ಮರ ಅದು ಟಿಕ್ಕಿನ ದಿಕ್ಕಿದೆ ಧಕ್ಕೆನ
ನೀರ ಅಂದ್ಬಿಟ್ಟು 3 ವರ್ಷ ಹೌದು ಕಚ್ಚೋಟು सोन वेरी अरे
ये सेकंड फर्स्ट लड़ाई को मस्त लड़ाई मरा काम वो धंधे वाला उनमें को टीम से देखा लेंगे है ना तो 12 वाला कहीं 12 ये कहीं प्रॉब्लम पार्ट चल ನೋಡಿ और देखो छोटा छोटे ಒಳ್ಳೆ ಕೂಡ ಹಾಸ್ಪಿಟಲ್ ಓ ಮಾಡಿ ಕಡಿಮೆ ಕೂಡಿ ಇದು ಮಾಡಿ I am somehow chief minister. I am post. You come do sir. Your last running pedos. Even Maharashtra is one. Potashi, Paradi, camera yes, चलती है कैमरा चला जी हाँ चला बोल बोल हम बजाय के बाद फिर चला रहा है अपने देश में कानून समझ बड़े साहब छोटे भाई ये शांत देश में भी होगा तो छोटे परिवार नमी पानी पड़ी चिंता पड़ी मन द्वारा कम करेगी ये मरे थे मगर ही मारो मन जाने भाटा पड़ूगा कन्नड़ मारे हेटती बुद्धि रहो आसरा देख मन मारे नहीं आता भाटा पड़े चमका रहा है चमका तो गस भाड़े लास्ट यार पुढे मग हे करतो समोर निघित यार सुद्धा स्टेशन निघित टी शर्ट से फाड़े ना ನಿಜ ಇದೆ ಅವನು ಏನ್ ಹೇಳ್ತಾನೋ ಅದೆಲ್ಲ ನಿಜಾನೇ ಹೇಳ್ತಾನೆ ನೀನು ಪಕ್ಕ ಸುಳ್ಳು ನೀನು ಕೊರ್ಮ ಇದ್ದಂಗಿದೆಯಾ ನೀನು ಟೀಮ್ ಮತ್ತೆ ಕರೆಕ್ಟ್ ಟೀಮ್ ऐसे नहीं जाड़ा में मारो दबासन मारो केक को कड़मे मारो ಅಂತ ಕಡಿಮೆ ಲೆಕ್ಕ लड़ाई कर भारी बारे में जगह हीरो ही भारी ಉತ್ತಮವಾದ ಫ್ರೆಂಡ್ಸ್ ಎಲ್ಲ ಫ್ರೆಂಡ್ಸ್ ಮಾಡ್ಬಿಡ್ತಾವ್ ನೀವು उम्मीद बारे में बड़ा होती है मस्त और माथे चढ़े रहती केम ग्राम को बोलो बाटली चढ़े रहने तो चुका माथे माथे मारा नीचे करोगे नहीं करोगे हाँ टिकले लड़ाई नहीं मैं ना पीना है तो मारे रो काश हाँ वजन बड़ा खाओ रहना की
खरा ये आदमी मारेगा ये करेगा तो मैं खरा काम नहीं मिला
मन में ये आईडी कार्ड वीसा कार्ड 3000 जो मत जो मत जो तो मत दिख रहा है मगर मोबाइल में चर्चा करेंगे मंदस में माना बस 7:30 फोन करो हाँ मत फोन आईडी कार्ड तो 10 बैंक वीजा वीजा ईमेल फोन जारी
We are into a part-heard matter, just 15-20 minutes. Yes, Mr. Nagar. So,
reducing my list of authorities. One judgment not available. Is at page 99.
oh. Yes.
That's great. Page 110. For somewhat recent decision, the question this. So what you see at page 114, it's an appeal against an interim order. The learned judge Lord had issued a certain direction permitting the voting of nominated members, but had directed that their votes will be put in the sealed cover and results should not be announced. Against that, Lord, this appeal was preferred. Paragraph 3. This intra-court appeal has been filed challenging the interim order dated so and so, whereby then single judges in interim measure has provided that elections to Bangalore Urban Local Authorities constituency for the Legislative Council shall go on. The respondents 3 to 17 will be permitted to vote in the election. The votes cast by the private respondents will be placed in the sealed cover, and the result of the election of the Bangalore Urban Authorities constituency shall not be declared without leave of the court. Special ballot box be kept for the voting of the private respondents. As such, votes be kept in sealed cover. That's how the matter arose. But please go to next page, 116, paragraph 5. Then counsel for respondent 1 on the other hand submits that Article 243 of the Constitution clearly bars persons who are nominated to municipalities to participate in cast vote in meeting of the municipalities. These persons can participate in the day-to-day functioning municipalities. However, they cannot cast their votes in the meetings of the municipalities. The submission is once they do not have any right to vote in the meeting of the municipalities, then they cannot be given the right to vote in the Legislative Council election. It is submitted that what is not provided in the Constitution cannot be taken for granted under the Municipalities Act. Then Lord Section 11 is noticed. And kindly then go to page 118. We are of the considered view that the question of participation of nominated members of municipalities in Legislative Council election was the main question before the writ court, which was required to be adjudicated finally as such. There is no case for interim relief. Since the writ petition is pending, we do not give any finding on the arguments made by other side. We modify the interim order passed by to the extent that the election of the local body's constituency should go on uninterruptedly. Nominated members who are respondents 3 to 13 can participate in the election and cast their votes. The result of the election of the Bangalore Urban Local Authority Constitution shall be declared. It shall be subject to the final decision. This is the judgment, Lord, which was relied upon before the learned single judge when he granted the interim order. This judgment, Lord, when we cited it, the learned counsel, Lord, senior counsel on the other side, he said the facts of this are different. It has nothing to do with the facts of our case. Therefore, his submission was that this is of no avail. This should not have prompted the learned judge to grant any interim order. That was the submission which he made. But my submission is only this, Lord. The question as to whether their right to vote as a nominated member is there or not was directly considered. And the Lordship now do get from an interim order directed that they have a right to vote and they can participate in the vote. To that extent, Lord, my submission is that this judgment is relevant. Then, Lord, this order, Lord, my instructions are that no challenge was made and this order became final. It has given effect to us. The argument was that this has nothing to do with the nature of the controversy which is presently before the court. Later on, Lord, I understand that the petition was dismissed as infructuous because election was held and the announcement was made. Lord, last two decisions which I rely upon, Lord, 11 and 12, that is, same word may be used in different meanings in one statute itself. The judgment begins at 128, 56 SCR. The relevant portion, Lord, is at 130, paragraph number 5. At the bottom, Lord, paragraph 5. There is an extract from Maxim.
One question, Mr. Naganan, is there like Allahabad decision you relied, right?
Yes, Lord.
So Allahabad decision, there is a provision like 54(1).
Yes.
Is there a perimeteria provision in Karnataka?
There is no perimeteria provision.
No. So they were considering 54-1.
Exactly.
In that context, they read down.
Yes. Yes.
Which may not be the case here.
No, I am only submitting not. The logic which the lordships accepted was that if you are, there is a distinction between an election meeting and a regular meeting. To that extent, not that judgment in my respectful submission supports my submission. But I respectfully bow down, Lord, that the same language in 54 is not contained in our act.
Yes. So page
now page 130.
130. Yes.
In that, Lord, just a few lines in paragraph 5. It's a long para, Lord. If your lordship could go down to the lower part of it, where extract from Maxwell is there.
Yes.
Maxwell's interpretation.
Yes.
It is at all events reasonable to presume that the same meaning is implied by the use of the same expression in every part of an act. The rule of construction contended for by the petitioners is well settled, but that is only one element in deciding what the true import of the enactment is, to ascertain which it is necessary to have regard to the purpose behind the particular provision and its setting in the scheme of the statute. The presumption, says Grace, that the same words are used in the same meaning is, however, very slight, and it is proper if sufficient reason can be assigned to construe a word in one part of an act in a different sense from that which it bears in another part of the act. So, not here, if you adopt the word meeting and give it the same meaning everywhere, as whatever type of meeting it may be, then I have to fail. If the interpretation is that the context of the word meeting used when it comes to regular business is different from the meaning attributed to the word meeting when it comes to election, then your lordship will not probably sustain my argument. If that argument is accepted. That's the distinction. So this is authority for that proposition. One more just decision of the same effect. Next judgment, which begins at 133, Venkateshwara Hatcheries case. Kindly go to page 143, para 19. The same word, if read in the context of one provision of the Act, may mean or convey one meaning and another in a different context. The legislature in its wisdom has chosen to place processed seeds and fish under the heading articles or things in the fifth schedule of the legislature is competent to give artificial meaning to any word. We are therefore of the opinion that the meaning assigned to the words articles or things in the fifth schedule cannot be assigned to the words articles or things used in section 32A and 80J of the Act.
Yes.
Then, my lord, last para 22, my lord, their lordships conclude in the same fashion. Now, kindly take my note. In that, my lord, I have tried to distinguish the judgments which have been cited with the other side. My note, my lord, that is written submissions, page 10, paragraph number 16. My learned friend, my lord, has relied on 4 decisions. The first one, my lord, is Savitri. Now, my lord, in this case, the right of MPs, MLAs to participate in no confidence motion was a question that was involved. Your lordship saw the language of the section, Lord. The section itself says how to compute the majority for the purpose, requisite majority for the purpose of removal. And it clearly says that for that purpose, nominated members not to be taken note of. So this decision dealt with such a situation. So it is of no use. 42(9) specifically says, in computing the 2/3 majority, don't take nominated persons. So that was an issue, and the lordship said that the section itself reads like that, so you can't take them. So that decision, my lord, in my respectful substitute, didn't deal with this question at all. The second, my lord, was Ramesh Mehta's case. There, my lord, was whether nominated members should be taken note of to compute the total number of members of the municipality. So, my lord, supposing there were 10 elected persons, 5 nominated persons. So, should 15 be the total number of members, or should 10 be the total of members? That is the point in issue. That is not the issue here at all. Then, my lord, the judgment in Pramila's case, my lord adverted to it and said that it was relating to the constitutionality of the provision 4243 are relating to mayor's election. Now, the constitutional validity challenged there is not the challenge which we have laid here. The challenge which we have laid here is all members of the municipality form one class only, whether they're nominated or elected. The constitution limits it to one extent. Would that limit be violative of Article 14? Is a question. Because how can you create an artificial division of this? And even there, they make an artificial division insofar as particular meeting is concerned. For no confidence motion, one artificial thing. For appointment, one artificial thing. For regular business, something else. So, my lord, I respectfully submit that decision also, my lord, has no bearing on the controversy which falls for kind consideration in this case. Okay. So many things have happened since, my lord, the litigation was commenced. As I submitted, my lord, the writ petition in which the interim order was passed, that writ petition was withdrawn with liberty to file a fresh writ petition because they wanted to challenge it. I am not appearing in that. I'm just stating the fact. I think Srinagar appears in that case where a fresh writ petition is filed and they are pressing their contentions. More or less, I don't think he's going to repeat the same argument that I have addressed is also there by them on the same lines.
Judgment, Lord, which have considered 9. This judgment, Lord, which the other side is relying upon. But the language of 42(9) was different before the amendment of 2003. The amendment was introduced from 28/2003 and it was necessitated because of a judgment of this one before, which is in the judgment compilation lot, which is at serial number 8, Yashodhamma versus State of Karnataka, which in turn relied upon Rais Ahmad Khan versus State of UP, which is at serial number 7. Because of there being no distinction between nominated and elected members, they held this one before. Then a single judge held not that they have to be reckoned for the purpose of identifying 2/3. And that judgment in Yashodhamma Lord was pronounced on 6/8/2003, which led to the amendment on 28/2003. At the time when this amendment is made to 42(9), Lord, consciously, my Lord, they have not amended 42(2). The language of 42(2) and 42(9), Lord, were the same till the amendment was made. While now, Lord, 42(9) deals with, Lord, people having, members having voting rights, which is introduced by an amendment. 42(2) does not, Lord, there is no change that has been made. 42(2) is governed by the definition of a member, Lord, which is there in 2(6), section 2(6). Therefore, my Lord, my submission is legislature, my Lord, consciously has amended, my Lord, only 42(9), and that is the basis on which, my Lord, it has been interpreted in Savitri's judgment. Therefore, in 42 itself, my Lord, there is a distinction. For some provisions, it is all the members. In respect of some provisions, my Lord, it is persons who have voting right in the normal meeting. But that's one submission, Lord, which I wanted to place. Other than that, Lord, if kindly have a look at Rule 3 of the rules. Rule 3 specifically says the election of president and vice president shall be held in the meeting fixed by the election officer. There is a Lord 243R B, Lord, has already been pointed out, Lord, to say that there can be law with regard to election specifically, which is not controlled by the proviso because it only controls A. Here it says, Lord,
this is the election officer who has to call for this particular meeting, because all other meetings are under Chapter 3. And Chapter 3, Section 47 specifically defines a meeting. To say the meeting that is contemplated under Chapter 3 is meeting called by the president who's elected. This is prior to that. And here, my lord, specifically the rule says that, my lord, it is the Tahsildar, who's the election officer, who has to call that meeting for the purpose of election. Therefore, my lord, my submission is this provision made is in consonance, my lord, with the constitutional entry also. Now, my lord, we had to withdraw the writ petition because what was suit against us in the original writ petition was there is a constitutional entry, and therefore this interpretation should not be adopted. Therefore, my lord, we made an application to amend the writ petition. At that point of time, my lord, because any challenge to the constitutional validity will come before division bench, so suggested, my lord, with liberty, we withdraw the writ petition. But we made a memo, and the court has permitted us to withdraw the writ petition and file a fresh writ petition, my lord. And that's how we now come before this on the fresh writ petition.
Yes, madam. Can we hear you after a little later? ASG is waiting is an outstation power. Yes, we are telling.
So Ravi Verma Kumar.
Yes.
We will hear you after some time.
No. First, the ASG has to be heard.
That's right.
The propriety requires the ASG has to. Thereafter, Advocate General.
Since he was about to complete, that's why we have heard them. And we will hear you after he completes.
Yeah, please let the ASG make his submissions. He has to defend Article 243R. And
no,
then
not in your case, some other case. Some other case.
Okay. Then in that case, may I request this may even be called tomorrow or day after.
Tomorrow?
Any. I'll leave it to the court.
All right. Tomorrow.
Please.
Mr. S.S. Nagananda, Lead Senior Counsel, and Mr. S. Sriranga have concluded their submissions. List for further hearing tomorrow. What?
Only one submission. Only one submission. I am not made a party to the writ petition which was argued by my learned friend Mr. Nagananda.
All right. Yes.
So therefore, he may be justified in not giving me a copy of the synopsis he has filed in that case.
Yes.
However, Mr. Sriranga has adopted those arguments, and therefore at least he should give.
He will. Yes. They will supply you today.
The list of authorities.
Yes. They will supply.
Fairness, I expect from Sriranga to give.
Yes.
Please.
Yes. Ask your colleague, Mr. Sriranga. Give that. Yes, Mr. Your some application, some matter is pending. That is expected. You can mention that. Yes. Which case, Mr.
Yes.
58.
Number 58 is Gautam Garudwar.
The union in this matter, we succeeded before the learned single judge. Very detailed and well ordered order, and just fully captured all the principles decided by the learned single judge is based on constitutional judgment. I am not citing any judgment because of all that has been brought out in the put the concept and refer the judgment paragraphs and leave it there. I don't have to include it. There is no need for it because all the five points have been decided, and I catalog all the 5 points in 2 minutes and then close it. But the issue today is for your lordship's consideration. There are totally 4 levies involved. That's the broad canvas.
the 4 levies of tobacco products subject to GST, subject to excise on GST, subject to excise duty, and subject to excise. These are the 4 levies which encompasses the tobacco products. As far as GST is concerned and cess is concerned, there is no quarrel. They are paying. Their objection is when we are paying GST and we are paying cess by virtue of Article 246A and 271. But GST is paid by virtue of 246 capital A and cess is paid under Article 271. Who are you asking us also to pay excise duty under Article 246, entry 1, list 1, entry 84, and also national contingent calamity duty, which is again traceable to Article 271. Why should we pay these 2 duties? As far as NCCD is concerned, their argument was for a brief period excise duty was nil. So whether NCCD should be calculated on excise duty, if excise duty is 0, how do you ask us to compute it on NCC? This was the case. At that point of time, Supreme Court was in their favor, which subsequently got reversed by a full bench judgment in Unicon. Unicon has said this is an independent levy. So both NCCD and cess are considered to be standalone levies and not contingent upon payment of excise. More so, it's very important. In the case of NCCD, it is based on value and not on duty. We can understand if excise duty, suppose they say 10% of NCCD on excise duty. Then if excise duty is 0%, whether you should still pay 10%, that also resolved in Unicon in our case, revenue figure. But here is the case, it is 25% of the value of the goods. So it has nothing to do with excise duty. Therefore, as far as NCCD is concerned, squarely covered by Unicon. And the learned judge has dealt with this into the improved judgments, paragraph 100, 101, 113, and 115. Squarely following the ratio of maintenance and Unicon. So NCCD goes. So what remains is only excise duty. But other 2 levies are not contested by. For excise duty, their case. For excise duty, their case is, look here, 246A directs you to demand GST on our products, on the supply of tobacco products, and also this corresponding cess under 271. How could you levy an excise duty on manufacture of tobacco products? So it involves 2 critical issues in terms of, is there a constitutional bar? When you impose GST, does the constitution bar imposing one more tax or duty tracing its power under 246? That's the question. 1. 2. The second question is, when you are taxing the taxable event for GST supply of tobacco products, when the taxable event for excise duty is manufacture, then manufacture gets subsumed in supply because supply is a subsequent event. Could you go back and also impose a separate levy of excise duty on manufacture? These are the only 2 questions which are not purpose of interpretation, harmonious interpretation, referring to any number of articles, any number of definition clause, ultimately boils down to these 2 principles. And that is decided by the knowledge. So what is the answer? Answer to the first question is there a constitutional bar? But we can always test a validity of the provision. Either there must be a constitutional bar, or there must be a constitutional limitation, or there must be a constitutional illegality. These are the 3 fulcrum tests whenever your lordship imposes examines a validity under the constitutional. So let me show to your lordships that this levy does not suffer from any one of them. But also guided Article 246. 246. I just spent only 5 minutes on that. A very short legal issue. Which is GST. The expression used is not subject to, but not except. This is the clear difference for what our judgments are brought. When you subject to something else, then you have to see the contents of that something else and then come back to this thing. If the expression used is not subject to but notwithstanding, it is over and above that. Plain, simple. Yes. In contrast, I not say 246. It uses both notwithstanding and subject to under the various clauses. I not say see, subclause 1. Notwithstanding anything in clauses 2 and 3, Parliament has exclusive power to make laws with respect to any of the matters enumerated in this one. We come to subclause 2. Notwithstanding anything contained in clause 3, Parliament is subject to clause 1, the legislature of any state shall have power to make such laws with respect to matters enumerated in list 2 and list 7. List 3. So when it comes to union list and concurrent list, expression used is notwithstanding. But when it comes to state list, it is subject to clauses 1 and 2. That's why, my lord, when your lordship examines fit and substance, whether it is first found in the constitutional entry. When your lordship applies for the test of applying the residual entry, your lordship will first apply whether it goes into the union list. Reason being, some state list is subject to union list. If something is found there, then repugnancy test will apply. It's not your lordship will consistently be holding this. So when consciously 246 subclause to use of the expression subject and 246 capital A does not use subject to but notwithstanding. Can we be, my lord, reading notwithstanding as such? We can't be rewriting this word. So there is no constitutional bar. Article 368. But the introduction of a bill for the purpose in either house of parliament, and when the bill is passed in each house in the majority of the total membership of that house, and the majority of not less than 2/3 of the members of the house present in voting, it shall be present with the petition who shall be his therefore, the constitution shall amended in accordance with the terms of the bill. Provided that if such amendment seeks to make any change, Article 54, 55, 73, etc., Chapter 4 also, any please be subclause, any of the lists in Schedule 7 is subclause 3. The amendment shall also require to be ratified by the legislatures of not less than 1/2 of the states by resolution to that effect passed by those legislatures before the bill making provision for such amendment is presented to the president. So, what have we done now? By introducing 246A, we have shrunk the capacity of entry 84 in list 1, limiting it to 6 products. Capacity of entry 54 in list 2 on sale, limiting it to about 5 or 6 products. And this shrinkage carried out in the 101st constitutional amendment, which I'll show in a minute's time, has been ratified by all the states unanimously. There is no dissent. The GST bill, it's a historic bill, which translated into act because union and all the states voted for it and for this transition without a single dissent by any state. Now, therefore, there is no constitutional illegality. Under 246, Quad 246, there is no constitutional bar. For the process, Article 368, there is no constitutional illegality. Third, constitutional infirmity. We will address now. If your lordship comes to the 101st constitutional amendment, for minute knowledge, my friends have kept it off to the technical constitutional parentage as it. If your lordship comes to the law, section 17 of the constitutional amendment. Union, now your lordship is in entry 84, which had all the products of manufacture, is shrunk to 6 products for that whole. Today, tobacco and tobacco products find space in list 1 entry 84 and also under the GST regime. And this shrinkage of the list 1, restricting manufacturing duty only on these 6 products, validly will not pass an amendment under 368 by the Parliament of the Union of States. So, therefore, the second threshold test is crossed. So the third threshold, constitutional infirmity, whether it's arbitrary, whether you can use 2 levies, 4 levies, answer is simple. There are 3 points they argue. One is they said argue that is violated Article 14. Why choose one product and not? For which one the learned judge has about 7 pages of the judgment is dedicated to public policy, tax policy, policy making of the Parliament and the legislature. How judicial review cannot be getting into stepping into the shoes of policy making, especially in a product like tobacco, which is considered to be a sin tax. That's what all that 7 pages of the judgment I'll give it. So this is how the arbitrary test was addressed to say that picking and choosing some products for both levies you can't say to tax some or one. You need not have to tax everything. That's a self-executive principle. Second point they argued was manufacture. How can you tax manufacture and also supply? This has been a time-tested doctrine applied for the past 32 years post Federation Hotel judgment in 1989, where we imported the Canadian doctrine of aspect theory. Lafroy's case, where suppose this computer, I import the parts, I assemble the parts and manufacture a computer. It is liable to excise duty. The same computer, if I sell it, I'm talking about prior to GST regime, it was also liable to be a VAT or a sales tax. So suppose this computer is 40,000 rupees. When I release a computer out of my factory, my invoice value of 40,000 rupees will have an excise duty content of say 20%, a VAT of 10% on the same 40,000 rupees. So question is it sustainable? Several judgments starting from Federation Hotels, which the learned judges also referred to in the judgment, have said, as long as you are able to find plurality of aspects in the constitutional scheme and the entries, if there is an entity to support a levy, then that aspect of the levy is sustainable independently. That's what is aspect here. So what is aspect? If there is an aspect of manufacture, then that aspect can be charged to tax independently. If there is an aspect of sale, you can tax it as sale. No, not sale has been substituted as supply. So their case was, does not supply subsume manufacture also, because you only put one tax on. The definition of supply under Section 7 of the CGST Act does not include manufacture. That's the critical aspect of it. We may choose to subsume it in some products. We may not choose to subsume it in another product. There is no constitutional bar. One answer the learned judge has followed Federation Hotels to say is, applying the aspect theory doctrine, both levies are sustained. Now, the second larger principle, which is more important, assuming it is double taxation. You are imposing on manufacturer, you are imposing on supply, we will not accept aspect theory very well. Another thing, constitutional judgment, although by Justice Krishna, but has said, which is followed even today. One can oppose double taxation only when executive imposes it, not by parliament. Imposition of 2 levies, or what we popularly call as double taxation, is not a constitutional infirmity. Because as long as Parliament exercises its power and has a field of entry to tax, today we are sustaining excise duty under entry 54 and GST under 246. One aspect your lordship will have to bear in mind, which is not ordered in BKC. This is very important. Unlike other taxation levies, GST is one unique levy which does not have an identified entry in list 1, list 2, or list 3. Why? Why? Because this one is exclusively union. This one is exclusively states. This one is concurrent. But concurrent is subject to what? State giving space to union. Should union seek to? So concurrency is subject to repugnancy. Concurrency is subject to other constitutional cases. Whereas GST is not any one of the three. It is a simultaneous levy, not a concurrent levy. Constitutionally, GST is simultaneous. Why it is simultaneous? Because one taxable event is one, which is supply. And both the federal partners to choose to tax at the same point of supply. So supply is the taxable event. Whenever supply takes place, union and states simultaneously will impose 50-50%. Suppose it's 18% tax, 9% by center, 9% by the state. This architecture will clearly get it for 246A. So instead of putting a separate entry as list 4, this has been incorporated in the article itself. One last see one last thing 246. Anything contained in 246 and 254, Parliament and subject to subclause 2, which is for interstate tax, the legislature of every state have power to make laws with respect to goods and service tax imposed by the union or by the state. So the field of legislation is goods and service. Who are the taxing partners? Union and the state, except in the case of IGST directly. So this again, BKC the Supreme Court has held it so, and that's followed in this judgment. BKC will not put first judgment on this point, which has said 246 architecture is 246 architecture is unique. It has both the source of power and also the field of legislation embedded in the same article. Unlike other taxing powers or other fields where source is traceable to 246, then you have to go to the reach out to the entry to see where it is. This exercise is, is made redundant because this is a simultaneous levy, and not this is the only unique levy as on date in the country where union and state together worked. It's the first experiment and a very successful experiment so far. We are proud to see that this March, in spite of all the pandemic and growth, we have hit 1,42,000 crores of tax revenue collection in the month of March. Now, when we dipped down to 22,000 crores, peak of COVID, 18, 20, 22, this was what we were making. Now, we were otherwise touching about 90,000 to 1 lakh crores. Past 4 months, it's more than 1 lakh, 1,10,000. March, we have achieved a target. Why? Because transparency, collaborative effort, cooperative, BKC put set stocks. This is a milestone achievement in a doctrine of cooperative service. Together, they are able to achieve what this space is. In a taxing enactment, to that extent, confined to this, these are the principles. So let me summarize, and then I'll take you to the lordship of the judgment. Three issues which do: constitutional bar, constitutional illegality, or constitutional infirmity. There is no constitutional bar because 246 and 246A, 246A only is notwithstanding and not conditioned or subject to, or because of 246, there is no denudation of power under 246A. That's the first principle. But the second principle is illegality. Article 368, subclause 2, Parliament and the states have validated the 101st Constitutional Amendment Act and they have approved the existence of entry 84 list 1 to tax tobacco product under excise duty, notwithstanding it can be taxed as a supply under GST. So the Union and the Parliament has passed a legislation. There's an underlying enactment line, so there is no illegality. Third, when it comes to constitutional infirmity, but there is no arbitrariness in taxing products. You need not have to choose to tax everything one. You have to tax everything else. So Article 14, between tobacco products, we have not discriminated. So that clause, as such, my lord, is a clause by itself. So it cannot. So one, no Article 14. When it comes to manufacturing, we submitted the two tests. You apply either the aspect theory or you apply the double taxation theory. Both ways, Union has the right to do it. Executive cannot, through a circular or a notification, introduce double taxation, certainly, but not the Parliament of the states. So, therefore, the three tests of either arbitrariness or manufacture or aspect. Manufacture is two parts, aspect theory or double taxation. Again, my lord. Now, my lord, therefore, finally, the test we have to see is under Article 265, know whether the collection, levy and collection is under the authority. When we pass these three tests, the ultimate inference we can say, does it have a constitutional authority? Because 265 mandates, there shall be no levy or collection without the authority of law. So, Lord, does it have a law in place? Yes, there is a law. Whether it is excise duty under the Excise Duty Act, or GST under the GST Act, or NCTD to a notification, or the cess to a notification, all of them are, and they have not challenged these as ultra vires. 265 tests of constitutional authority also gets passed. Lord, I'll just show the Interim judgment. What is that? Whatever has been now captured as concept in your lordship's vote is found in the judgment. And in our very humble view, Lord, it may not require an interference in our very respectful due to the lordship. We pray that we should be upheld because it has followed decisions of constitutional benches while not allowing this case in our case. My lords may come to the consideration at page 89. You also can take the BS products. So that was a real matter when you that's you. You also take BS products, page 89. But please see 89, 84. Chapter entry 84 is extracted by the Honest Judge. At page 90, 246A is extracted. And about 5 lines below, in page 90, the words notwithstanding anything contained in Article 246 ought to be construed as having the effect of merely clarifying that in spite of the power under 246, power under Article 246A could be exercised, and that Article 246 would not be an impediment to the operation of 246A. And why this is the ratio with the learned judge has said, following the earlier judgments of the Supreme Court on notwithstanding. So this is finding one. Finding two, Lord, at page 91. Sanghavaka Sita Rao judgment is referred to. That principle is important, which reiterates last 4 lines, which reiterates the above position, while explaining that the effect of notwithstanding clause would merely amount to declaring that in spite of the provisions mentioned in non-obstinate clause, the provision would have to have its full operation. Then, Lord, from 92 onwards, again, and Lord, please come to 93. Accordingly, use of the words, notwithstanding anything contained in 246 in the present scheme, would not have the effect of extinguishing the exercise of power under 246. Taking note of the intention as reflected in the conscious amendment of entry 84 of list 1, it could be construed that even post introduction of Article 246A, there would be protection and continuation of exercise of power under 246. Observations the apex court in Union of India versus PKC Footsteps is apt in the present context. It's a recently argued Malott laid it under the GEC. His Lordship Justice understood and just said, Marsha, bench constitution. Not please. They have extracted para 29 is apt in the present context. With the enactment of the 101st Constitutional Amendment, entry 84 of the Union list has been restructured to incorporate duties of excise on the following goods, manufactured products, subclause 6, tobacco, and tobacco products. 94, the contention of the petitioners that 246 and 246A are not mutually exclusive, and to that extent, special power under 246A is exercised, there is delineation of power under 246 is liable to be rejected. The sources of power under 246A and 246 are actually mutually exclusive and could be simultaneously exercised. If that were to be so, the court ought not to forbid the union from exercising power under 246, which is not otherwise prohibited. It is noted that the first 101st Constitutional Amendment Act introduced 246A, which identifies the field of taxation as well as the source of power. No doubt, GST is levied on the products by virtue of introduction of Central Goods and Service Tax Act, the amendment to 246A. But as discussed, despite 246A containing a non-alternate clause, the power under 246 stands protected. No doubt, it has been contended there is a clear distinction between source of power and field of legislation, but the entries in the list being field of legislation cannot be considered source of power. It must be noted that Article 246 continues to be the source of power even post introduction of 246A. The amendment of entry 84 to list 1, whereby field of legislation indicating levy of duty of excise on goods manufactured or produced relating to tobacco and tobacco products, does indicate the conscious intention to preserve the exercise of power under 246 even after the introduction of 246A. But this takes care of a lot that there are two more paragraphs. I just permit one paragraph again. If the argument of the petitioner is that post introduction of Article 246A, and if on the product by virtue of goods and service tax under 246A GST has been introduced, there would be no power to take recourse to 246 read with entry 84 list 1 levy excise. It would in effect render the restructuring of entry 84 of list 1 redundant. Such an interpretation is to be avoided. Further, irrespective of the restructuring of entry 84 of list 1, the power under 246 remains unaltered. The intention of preserving such a power under 246 is further reflected in the repealing and saving clause of 174. So this answers, my lord, 246 overlap. Then, my lords, the question comes to, my lord, page 99. The concept of manufacture. Of the Supreme Court judgment in Mohit Minerals. Mohit Minerals have observed that even post-Constitution 101st Amendment Act, there would be no bar for levy of surcharge, even if there was a subsummation of various taxes. The relevant observation is as follows. So please see below at page 100. Mohit Minerals is referred, paragraph 56 has been extracted by the learned judge. And that is enough, sufficiently. Accordingly, the legal argument based on intendment of avoiding cascading taxes will not have the effect of prohibiting a levy of tax, which otherwise is permissible as power under 246 remains protected and preserved. So cascading, my lord, is a policy decision. To what extent you should cascade and to what extent you can impose. Now, merely because GST works on a cascading principle or subsummation principle, unless there is a constitutional bar, you can't say you have adopted this policy approach, therefore don't put the tax there. But their purposive construction, all these interpretative rules they want to interpret by saying you have taken a policy for to go in a particular direction, therefore don't impose. Our answer is 95% of the products are following this policy. But when drafting this policy of cascading, we have carved out a set of products to outside it. It's a policy choice. Please do not substitute it judicially. This is where logic stops. So, And this is exactly what the learned judge says, not 101, last paragraph. Must be noted, also noted that legislature enjoys a wide latitude to decide on the methodology of revenue generation, and the court should not rush and must tread carefully while dealing with the legislation based on fiscal policy. In the process of achieving ultimate goal, as envisaged while introducing the GST, the continuance of the levy under the previous legislations, unless barred, ought to be permitted as being competent vis-a-vis the available source of power, which cannot be defeated by the resort to an argument based on the objects of GST as contained in the object clause. So you can't say, when the statement of objects says remove the cascading effect. Remove the cascading effect is an objective, but not the killing in the absence of prohibition. We can't say because you have an objective, you denude. You consider this as denuded, but far-reaching. That should not, that overlap is not available because the test is always the reverse test. Because of statement of objective, is there a prohibition? Show us. There's no prohibition. You can't be reading the statement of object out of context to say what is otherwise available should be construed as constitutionally prohibited. That will be rewrite the Constitution. That will be actually amending the Constitution. When it comes to 102 onwards, lots of states taxable event issue on NCC. What is the aspect theory? This was the judgment I was referring to. The petition of 14th was 1988. This is the first judgment. They had not been imported the Canadian doctrine of aspect theory left us. Then para 86 is extracted there, and please come to 108. Case, the question as to legislative competence of the union vis-a-vis the state is not in question. The question as to whether power under 246A, which is a tax on goods and services, if levied on a product, could also be subject to a levy of indirect tax on the same product in exercise of power under 246. While the power under 246A provides for a simultaneous levy by the parliament and subject to 246A2, the legislature of every state, on the other hand, power under 246 with the union, the question of legislative competence under 246A vis-a-vis 246 would not strictly fall within the ambit of the applicability of aspect theory. Even otherwise, while it is aspect of supply which is the consideration while levying taxes with GST, it is the aspect of manufacture that is for consideration when levying excise duty. Though it is contended by the petitioners that the aspect of supply has subsumed manufacture, and accordingly, the levy of tax would in effect be on the same taxable element of manufacture in the present case. However, closer scrutiny would reveal that the legal taxable event under GST would be on supply, while on excise would be on manufacture, which are two different legally recognized aspects. And even if the incident is on a single subject, the different legal aspects would not lead to an overlapping and would result in treating the levy of tax as on different aspects. It is what 110. Even otherwise, even if it is construed to be a tax of the same aspect, unless such levy of tax falls foul of the other constitutional safeguards, it would per se not vitiate levy of tax, having the same double taxation. So this takes care of that aspect. Then not NCCD, which is the last one. Their lordship has followed unicorn. Not that your lordship will get it there. 113, the principle and then following unicorn. It refers to two Supreme Court judgments. Accordingly, it becomes clear that surcharge is a methodology for raising additional revenue and has nothing to do with the leviability of the tax or the assessee's liability to pay the tax. And then NCCD as a surcharge traceable to Article 271. But please come to 115. There's only one bar under Article 272 that is captured in the judgment. The only bar under 271 is that surcharge contemplated excludes the surcharge as regards goods and service under 246A. In the present case, the surcharge is by way of a duty of excise and accordingly cannot be construed to be a surcharge as regards GST. 271 law prohibits a surcharge on GST, but not a surcharge on 246. The exclusion is limited only to 246A and not to 246. So the learned judge says NCCD is traceable to excise duty. It is not on GST. So therefore it is levied. And for last para 160, first para, the interpretation of the petitioner that surcharge cannot be levied under 271 as regards those goods and services which are included under 246A is liable to be rejected, as no such restrictions could be placed on the plain reading of Article 271, which provides that surcharge could be levied at any time to increase duties or taxes. In fact, surcharge being imposed by way of Finance Act has nothing to do with surcharge and GST that may still be levied. As levy under 246 is permissible even after the introduction of 246A, the levy of surcharge facing its power under 271 would still subsist even if goods are subject to the levy of Goods and Service Tax Act under the 246. Then what period of exemption NCCD, which brought to Lordship's comes to 117. Bajaj Auto was one judgment which was against us, briefly for 1.5 years. Then there are two judgments which Lordship is down below. Modi Rubber, which is a 1986 judgment, was not shown both in Bajaj and SRB nucleus. So Bajaj on NCCD, SRB and cess went against the revenue. Notwithstanding the 1986 judgment, which was again full bench 3 judges contrary to it. So they held both Bajaj and SRB to be per incurium in 1.5 years' time, in the unicorn judgment. Subsequently, it's there at 117. It must be noted that the argument of the petitioners were relying on the judgment in Bajaj in this case has been clarified by the judgment of the Apex Court in Unicorn, where Apex Court has declared that the judgment in Bajaj Auto to be per incurium. It was also held Apex Court judgment in Modi Rubber was not considered earlier in Bajaj Auto and SRB. In the case of Modi Rubber, it was clearly held the exemption of excise duty under the Act 1994 could not be extended to the exemption the levy of under the Finance Act. So that is so at 118, the learned judge finally concludes. Accordingly, though notification 2/2019 reintroduced a nominal basic excise duty, the levy during the period 36/2017 to 16/7/2019 is not disturbed, and accordingly, the relief sought for in by the petitioners for refund of NCCD during such period is liable to be rejected. It must further be noted that even though NCCD is the nature of duty of excise and may be construed to be an additional duty, yet it is an independent levy, and exemptions granted on excise duty cannot prohibit imposition of other additional duties or levy, and accordingly, there is no bar for the operation of NCCD. That this last 5 pages about I take only 5 minutes as follows. This is on Article 14 on policy making. I read only this section and leave it there. 119 only. At the outset, it needs to be noted that the petitioner has not raised any contentions in pleading regarding the attack of levy of basic excise duty at NCCD on the ground of it being violative of Article 14 of the Constitution of India. It is only the written submission that such contentions have been raised. The case that is made out is tobacco and tobacco products are the only category of goods which are subject to indirect taxes under 2 regimes, GST regime and the excise regime. Grounds of challenge are unreasonable classification, manifest arbitrariness. It must be noted the respondent has countered such contentions on the ground that the twin test of reasonableness and rational nexus is achieved if taxation on tobacco is viewed as a sin tax with other underlying object being of revenue generation. Then not the learned judge, the Apex Court, not all the judgments, I just submitted one paragraph in 120. It is settled principle that legislature has a larger discretion in matter of classification for the purpose of tax. The requirement, however, is that there is a classification and a rational nexus between such classification and the objectives sought to be achieved. As regards such aspect at the time of oral submission, it was pointed out that the levy of NCCD was only to discourage consumption. It is that fact to be taken note of. The classification of tobacco and tobacco products as a separate class, keeping in mind the object of discouraging its consumption, and such classification could be stated to be based on intangible differentia. Having so classified the levy of NCCD, which is for the purpose of discouraging consumption related to object associated with levy, cannot be described as. Then Lord Illinelli Hotel's judgment. fiscal 2 and well, once we come to 120, last 2 pages. Parentage. It was already noted that levy is also for the purpose of revenue generation. The choice of the category of goods for the purpose of revenue generation cannot ipso facto be a ground of judicial review, and something more is required, such as hostile discrimination and singling out a category of goods. In fact, the choice of category of goods, as in the present case, may also be influenced with the object of discouraging consumption, and accordingly, the choice of category of goods for the purpose of revenue generation cannot be held to be arbitrary. As regards the aspect of manifest arbitrariness, finding its base in Article 14, it is accepted that this principle could be pressed into service where the arbitrary actions have elements of caprice, irrationality, disproportionality, or excessiveness, and being characterized by a lack of determining principle. There are no grounds made out in the pleadings calling for the application of the said principle. This is what my friend was repeatedly saying. Please don't fail to mention this. So glad I thought I should mention it. Thank you so much. Para 30. Further, the levy of tax is a product of legislative choice and on policy decisions which are prerogative of the executive. And as laid out with the apex court in the case of BKC footsteps, the courts are not to be readily entered into adjudication of such issues. The present case, while entering upon adjudication of the basic of contention relating constitutional validity and observation, para 81 of BKC footsteps needs to be kept in mind. Such an interpretation, if carried to its logical conclusion, would involve unforeseen consequences, circumscribing the legislative discretion of Parliament to fashion the rate of tax concessions and exemptions. If judiciary were to do so, it would run the risk of encroaching upon legislative choices and on policy decisions which are the prerogative of the executive. Many of the considerations which underlie these choices are based on complex balances drawn between political, economic, and social needs and aspirations, and are a result of careful analysis of the data information regarding the levy of taxes and their collection. That is precisely the reason why courts are averse to entering the area of policy matters and fiscal issues. They are therefore unable to accept the challenge. In the above factual matrix, keeping in mind the guidelines laid out by the Supreme Court, no cases made out for interference on the ground that the levy being fixed by the law. That's all this 40 minutes.
No, please take your own time. We are not in a hurry.
No, not that time. It's a delight. I thought it's a very important constitutional principle. And the learned judge has said we argued it for days. Today we have suppressed it and compressed it in 40 minutes because everything is found in the judgment based on earlier laid down principle of law. So, Lord, tobacco is a very sensitive product. It gives us a tax of about 54,000 crores. The annual collection of about 7 lakh crores. And levies together will not constitute 2,000. Maybe 150 crores, they ask me for interest waiver, all that. But they're all not subject to judicial disposition. They're all tax policies. And therefore, my Lord, policy makers' choice should prevail. And should particularly thank you. Thank you. I was looking forward to one address at least before your lordships. I got it today. I'm so happy.
Thank you.
Thank you.
Oh, we thought you would take time.
No,
all right.
10 minutes.
Yes.
The first main contention that was raised by the learned solicitor was that there is no constitutional bar. But our entire contention is there is an express constitutional bar as found in 46A. Otherwise, there is, even if it were to be taken, that there is no express constitutional bar, there is an implied bar, and in that regard, we didn't place reliance on the relevant passages of case 1 of the matter. The second point, my lord, there is no constitutional illegality. For this, my lord, the 101st Amendment was relied upon, saying that there is no amendment to NG 84F. My lord, specifically, my lord, the judgment of BKC was placed before my lord. Now, my lord, if I may only request my lord to have the judgment of BKC. Contrast two parallels, BKC with Bimal Ghosh's law. In BKC, my lord, at page 208 of my judgment compilation 1, my lord, my request to page 208. The page with 3 lines from the bottom. This is what the knowledge is going to extract. If the enactment of the 101st Amendment, 1884 of the Union legislature restructured to incorporate duties of excise on the following goods, namely so and so. And my lord, placing reliance on this stray observation, my lords, the single judge also says, my lords, now the Parliament has in effect given its imprimatur to levy excise duty on tobacco products. Now, my lords, I may request my lords to kindly have page 313, my lords, to Bimal Ghosh's order of the judgment compilation itself, 313. 313, my lords. Judgment begins at 302, relevant at 313. My lords, para 29. Must be remembered that this court repeatedly held that entries in the various lists of the same schedule are not forms of legislation but are only indicative of the fields which are the appropriate legislature is competent to legislate. Para 30 minutes over the page. The task of this court in identifying the scope of an entry in the list contained in the same is not easy. By examining the scope of entry, this court must necessarily keep in mind the scheme of the constitution relevant in the context of the entry in question. Now, my lords, when the judgment of BKC was dealt with, my lords, this issue never cropped up before the Honorable Supreme Court. It was stray observation. My lords, based on this stray observation, it cannot be said that the Supreme Court has given its imprimatur to levy excise duty and NCCD on tobacco and tobacco products. Now, my lords, the next allegation was raised so far as Moët Minerals is concerned. My lords, Moët Minerals again in this judgment compilation, my lords, at 164. But before coming to Moët Minerals, I mean, this place relies on Article 271. But the learned single judge, my lord, and as contended by the learned solicitor also, my lord, it has been contended that there is no bar to levy NCCD by placing reliance on Article 271. My lord, so the face of it, my lord, Article 271 expressly states if you fall under goods and services which is traceable to 246A, you cannot levy a surcharge traceable to 271. My lord, if I may request my lords to have Article 271 as a can anything in 269 and 270, Parliament may at any time increase any of the duties or taxes referred to in those articles, except the goods and services tax under 246A, by a surcharge for the purpose of the union, and the whole of the proceeds of any surcharge shall form part of the consolidated fund. So, my lords, what does Article 271 in other words say, my lords? It says that if you are falling under excise duty, which is otherwise traceable to Article 246, by all means, my lord, they can place reliance on 271 and increase the surcharge, but not if it is falling under 246A. This would be my respectful submission on this. But one which we have not shown, the fourth schedule to the Excise Act came to be amended. My lord, the Excise Act. Page 97. Page 99, page 100. That's page 100. Yes. Now, only two categories are left in the fourth schedule. The first category, that is chapter 24 goods, that is tobacco and tobacco products, and my lord, at page 103, in 100 to 103, deals with chapter 24 goods, which is tobacco products. At page 103, my lord, this is chapter 27 goods. Chapter 27 goods fall under entry 84A to E. Chapter 84A to E goods do not come under the GST regime. They are kept in abeyance by virtue of 279A5 for the time being informed. Only what is being taxed today is tobacco and tobacco products. Now, the judgment relies based on the judgment of moitement bills. At page 164 of my judgment compilation.
Yes, yes. Just for reference, can we just place that? Yes, yes, please. Tomorrow. Yes. First, we
because the issue with involvement is at 164, we only place para 1. We granted the validity of goods and services tax compensation to states acts enacted by Parliament, as well as the goods and services tax compensation rule 2017 framed by the central government in excess of power of section 11 of the GST Act are challenged. My lords, there the challenge was to levy a surcharge under the GST regime. And my lord, at para 56, that is internet page 179, judgment compilation page 179. 179. My lord, it is in this context, my lord, the Supreme Court said yes, under the GST regime to have a power to levy surcharge. It is not our case, my lord. There is no power to levy surcharge. In fact, there is a compensation cess of 160% that is levied against me. My lords, but this surcharge cannot be traceable to 271 would be our respectful submission. The last provision which I would be computing, my lords, was made in relation to the applicability of Bajaj SRD was overruled in Municipal. Now the judgment of Bajaj in SRD was in fact overruled in Municipal. There is no dispute about that. What was the context of the judgment in Municipal? Municipal was the case, so as Modi Rubber, Bajaj or SRD, all these dealt with pre-GST regime and interpretation of exemption notification under the pre-GST regime. They were never interpreting a scenario where there was a pre and post GST regime. In this regard, the recommendation of 566 of the judgment compilation. From industry development in northeastern region announced the office memorandum dated 24/12/1997 specific fiscal incentives including total exemption from tax to the new industrial units and substantial expansion of existing unit in northeastern region for a period of 10 years from the date of commencement. The government of Sikkim with a notification dated 17/2 notified new industry whether all fiscal incentives available to the industry would be available to set up. Well, this interpretation was, if there is an exemption of basic excise duty, would that also include an exemption of NCCD and other cesses? This can be answered in the negative, saying that there has to be an express exemption even of NCCD. But my lords, there was one pertinent observation which is given in our favor, my lords. If I may request my lords to have para 48 of this judgment itself. 589. About 5 lines from the bottom, 3 lines from the bottom. Para 48. Background of the panel. The notification could not have contemplated the inclusion of education cess and higher education cess imposed by the finance nature duty of excise. The duty of NCCD, education cess, secondary and higher are in the nature of additional excise duty. So if my lords were to accept our contention that excise duty could not be levied on tobacco and tobacco products, my lords, NCCD only flows, my lords, from excise duty. It is only a surcharge which is in the form of an additional excise duty. Manoj, lastly, Manoj, on Article 14, Manoj, they only asked me one question. Every product, Manoj, from a pin to a plane today, Manoj, there is only one taxable event, excluding the categories which are specifically kept out. That is, Manoj, the taxable event is supply. Manoj, so far as tobacco is concerned, the taxable event of supply ceases to is there, but also, Manoj, there is a taxable event of manufacture. Because the entire GST concept, manufacture and supply, manufacture and sale, stands subsumed into the concept of supply. Therefore, there is a clear violation to seeking out only this.
Whatever
Yes, yeah.
The same Venkatraman learned ACI with Mr. Jeevan J. Negal. And write his name also, Mr. Bhagwan Learning Council for the petitioner. ACI concluded its submission. Submitted the rejoinder submissions. It is reserved for delivery of Karnataka land grabbing prohibition. Madam, Robert, what is it that guidance of that act? Yes, madam. Oh, this proceeding also is in this have the presence in this state petition, comma. The petitioner has prayed for the following reliefs: 1, 2, and 3. Right? 1 and 2. Paragraph. A division bench of this court by judgment dated so and so, passed in WP number so and so, has already upheld the validity of the Karnataka Land Grabbing Prohibition Act. Full stop. The reasons assigned in the aforesaid judgment, comma, the validity of the act is upheld and the challenge to the validity of the act is repelled. Full stop. However, the petitioner is granted the liberty to take recourse to such contentions as are available to him in law in the proceeding before the Karnataka Land Grabbing Special Court and below with the aforesaid liberty, the petitioner is disposed of. The same other case, same matter. Important in this, give Mr. This petition has challenged for the rate for the following relief. Same order. Ask for matter the number of petitions. 52 is same.
52.
We have disposed of with the liberty raise all contentions before the Karnataka special court. Yes. 2. Who is appearing this person? There is some.
No, it's there from right from 230 is there.
But 230. Oh.
Under some tree.
Oh, yes. Not getting signal. The same matter is following relief court, then disposed of with liberty.
Notes appear for the petitioner. Not objections are not yet filed. Notes. Virus of Section 68 of Electricity Act and Section 10.
To file
Respondents' notes.
objections, if any, on behalf of respondents be filed within a period of 4 weeks, list after ensuing summer vacation.
I appear for the petitioners in this matters, my lords. Yes, my lords.
Yes.
Yes, my lords, may I seek a short accommodation, my lords, the next week, beginning of next week, my lords, because I am a little unwell today.
Not well. Oh. It has next week.
My lords, 12th. My lords, 11th or 12th, my lords.
Yes, madam, 13.
Yes, my lords. Yes, my lords.
Write her name, Lorette counsel for the petitioner, praise for mark everybody's presence. Right? Write her name, Lorette counsel for the petitioner, praise for adjournment. On the ground that she is unwell. Yes, on 13th April. No, there is some urgency, madam, in these about these cases.
Yes, my lords, because these matters, the credentials of all the petitioners have been withheld and their permanent registration is not given by the Department of Medical Education. And they all belong to management and NRI quota students, my lords. They have questioned the law itself of a compulsory service, which is imposed on these candidates also.
The candidate will work. Given generally.
Oh, why it is listed for hearing? Mr. Jeevan Jainiragi, learned additional government advocate correspondence to court. Praise for his granted 4 weeks time to enable him to file notice. If this staff is doing summer vacation.
Number 56, the Abhishek Mali party, government advocate, Sri Ramesh.
Yes. By mistake you opted for NRIC. So Mr. Ramesh, what do you say?
Once they have taken a seat, they cannot go in the current process. Here in this third row, what should we use? Very costume.
Already there, right? No.
Annexure B.
Annexure.
It's annexure B, no? This is already there on record.
Is not in full. So,
the students were informed how the object has to be done. In this particular case, here from same college, there are only three types of seats. One is government seats, one is private seats, another is management. And this student is concerned on this college. He has picked all the three his objects. All the three types of seats he has opted. As per his desire, the computer runs, and it has given him a management seat only. Now he doesn't want that management seat, he wants to put another management seat so that his name should be included in the list to this section. That is the case.
NRI seat, right?
NRI seat. The student will be hard to. The only thing is between the. But after once he gets the seat, he is not entitled to. He gets exited. That's what I can put it to. That is what the NCA says. They get exited from the.
What is it?
Item 4. Item 5 is state north of Kotaro. But 3 exit is not there blank. Exit feature is also not available for him. Inevitable further routes of poisoning is there. That's one other. And then question also. Question number 35, the previous page. Will there be any question? Registration for
35. Oh.
No, there will be no fresh registration for stay vacancy law. The same time vacancy, list of registered candidates should be provided with DGSs to the college of stay vacancy law as per the directions from the input direction and as per the regulations of the agency. And all these procedures aspects are involved after this Sarun Para 3, 4, and how the procedure will go. This cannot be in the rule of application. In the case of Ashish Ranjan, there shall be only 2 rounds of common counseling, each conducted with DGSs or state government or authority designated by the state government for all India quota, including the university and state quota seats respectively. After the second round of counseling of all India quota seats, the students who take admission in all India quota seats should not be allowed or permitted to vacate their seats. This is what we also adopted. This would ensure that very few seats are reverted to the state quota, but from all India quota to state quota. State quota, and also all India quota seats are filled by students from the all India merit only. Students who take admission and secure admission in universities pursuant to the second round of counseling conducted by the DGSs shall not be eligible to participate in any further rounds of counseling. Then what is that? Also, procedural law. The students who secure admission in MBBS course pursuant to the common counseling
conducted with the state government at the time of common counseling itself should be made to deposit with the admission counseling committee the demand draft towards the fee payable to the institution or college or university. The admission counseling committee shall forthwith forward the demand draft to the specific institution or the colleges. The necessity for including the above mentioned requirement has arisen as it has been time and again noticed that when students report to the colleges after the counseling, they are refused admission by the college on some pretext or the other, and it is shown by the college as if the student never reported to the college for admission. If the demand draft is deposited by the admission counseling committee, then there is no scope for colleges to refuse admission. In order to ascertain the number of seats, this is 1 to 10 million here. In order to ascertain the number of seats that still remain vacant after the counseling, the state government or the authority designated by the state government shall conduct manual counseling for allotment of students. After the completion of counseling, the state government shall determine the number of seats that are still vacant and thereafter shall forward a list of students in order of merit equaling to 10 times the number of vacancies to the medical college, so that in case of any stray vacancy arising in any college, that seat will be filled up. This is procedural round. We have combined chronology roster. Procedural round. One they take in the second round is the obtainer seat. But they have to necessarily go and admit to the college. In this case, he was allotted a management seat. He did not go. Now, when he wants his name to be, if he doesn't go and pay the fee, he loses that seat. And he gets exited from the so he wants now his name to be included in the space seat vacancy. That's all. The spaces will be given only to those persons whose names are found in the list.
In the second round, at page 90, page 19, we have about 60 colleges preference. Colleges choice was given. When you say this, we also included a NRI quota of Saptagiri Engineering College. Today, we asked the committee to know that they have made a mistake, that it was allotted to us on 8. Today, we surrendered, and the surrender of seats was accepted on 12. Okay, it was accepted. According to the rules, are not in consonance with the rules. The rules go with the rules. Selection of candidates for admission to government seat rules. On the last time I gave a copy of the rules to you. Selection of candidates for admission to government. Page 709 of the followed in the procedure followed in conventional procedure followed in gradual vacancy. The heading is clause 6. The previous page last lecture. It will not be the proviso. Whether that the candidates who have been allotted medical or dental or Indian systems of medicine of the earlier round and who wants to opt for an engineering or technology or architecture taking the gradual route, can invariably surrender the medical or dental or Indian systems of medicine or homeopathy. If one day before the commencement of respective casualty for medical, dental, Indian system of medicine and people. This provision is applicable to engineering or technology or architecture system. Candidates who have been allotted medical or dental or Indian system of medicine, okay, or engineering or technology or architecture, and also candidates who have not been allotted anything. Here are earlier rounds, all eligible to consider for allotment in the casual vacancy round. They can also surrender, and they are also eligible in the casual vacancy round. It provides for a surrender of a medical seat before the commencement, then he can participate in this. Now, in the medical council rules, which my learned friend has now read, the rules which my learned friend has referred to. Internal phase, in-phase 32. Mop-up process. 32 was the MCA. I want to find it.
Regulation.
I filed it along with the memo. We have marked I have filed it along with the memo.
Oh.
Internal page. Start from page 7. Please use the counseling bulletin. All in there. Here an internal link page 10. Page 10 of the mop-up from. Registration is payment of registration fee for mop-up from for the following candidates who registered in round 2 and exited with forfeiture of fees can register again with payment of fees. It only says that if you have surrendered, if you have registered and you will forfeit that amount whatever you have paid, you can once again register what is provided in this. There again next is page 13, page 13, question number 10. The candidate does not report with allotted college during round 2. Whether he has to register again for mop-up from. Yes, the candidate security amount will be forfeited. He has to register front in mop-up from the specified. I have made a mistake. Now this subsidiary college, the entire 50 seats, NRI seats have remained unfilled. Nobody has opted because the amount of fees is nearly 60 lakhs per month per year. Whereas in the management seat, the NRI seat 60 lakhs. Management seat varies from 6 to 20 lakhs. I'm not in a position, it is not a management straight away. It is not a management seat as such. If it is a management seat, I have no difficulty. It is a management NRI seat. In the page, in the very same memo, at page 6, the availability of seats in the NRI code. The same one. In the middle, MO 64, about 10 columns from the bottom.
That you told us all 50 seats are vacant.
All seats are vacant. Not that I wanted to lock the seat, give it to some other student so that another student can apply. That would not arise in the present case. But also what the MCA regulation, which I regulation also
In order to prevent seat blocking in common council for permissibility to exercise first choice during council, forfeiture of fee shall be in accordance with matrix contained in appendix F. Now, this appendix F is there in the last page. The time schedule. There are in the last but one page appendix F starts. You have to go to the last page where the column is there. The following matrix in the applicable with regard to permissibility of the student to exercise first choice during council. There at serial number 4, state quota 2. Exit with forfeiture fees is not joined. Now the question of merely because they allot the seat is not relevant. If they are not joined, then only exit with forfeiture fee. Now ineligible for further counseling only is joined. That means so, Lord. Therefore, according to the need rules, I have not joined the college immediately as surrender. So therefore, the only thing that can be done is to forfeiture of the fee, which I have done. They have forfeited the amount whatever I have deposited. I am only saying now the mop-up counseling stage I have come to the point now because of now that mop-up counseling is also there, is also over. So what remains is only to include my name in a spreadsheet list according to page 17 in that memo, which we have issued the press note, where they say that if there are vacant medical seats which remain unfilled after completion of the seat allotment in mop-up round, that list if it is included, it will be available and get it. Otherwise, tomorrow I will get to understand it.
You have to explain what is, that's why we had adjourned it. He had shown us the rules and regulation and what you have to reply. You have only relied on brochure. He is saying brochure is not consistent with the rules, whatever.
Brochure is not the rule. First, promulgate prior to this. Thereafter, the procedural clause have been.
But what happens to this rule?
Yes, sir, I saw the rule. That rule will not now stand for 2012 will not that rule was made.
No, 6.
2012 was the amendment. Thereafter, Lord.
Which amendment? Which rule has been amended?
That rule was amended in 2005.
Where is it? Where do we get it? Six rules, right? Go page 711. Please, what do you say? What is it? Where is it? Have you given it to us? No, so what is it, Mr. Now tell us. Which page? Yes, yes.
Page 30-37. Now,
Huh?
the amendment, the last of the amendment was 2005.
Which page?
Page 30 and 37.
30. Yes.
Thereafter this judgment case, the rules, the procedural aspects get imbibed in the brochure. Therefore, this honorable court has held that within the decision of this honorable court, the procedure described in the brochure is to be considered as a
Ah, Mr. Natraj.
This paragraph 4 and at page 4, paragraph 4, but you have to go to page 4.
Yes.
Referring to the AS Punjab and Haryana, the majority of the full bench was that the information brochure has to be treated as a finding, and unless the condition of the brochure is struck off, the court would not amend the provision contained in the brochure or will not rewrite the same. In our view, the condition in the brochure, as referred to here below, is clear on its own title. The brochure has to be treated as a rule known as the abuse of the. Another thing was that he had the option of changing the choices, deleting the choices. If you want the brochure, he did not avail that. He goes to the first round, he did not get. He could have exercised that option of deleting the NRIC. He did not exercise that. So only when the seat gets allotted, now he makes a
Further reading. Number 57, Srimati D. Ganta Vasanti, C.J. Satish Kumar, C.G. Bhakti Reddy, M. Ashwat Narayan Reddy.
He is opposing the prayer for adjournment, madam. You know, you told that you are, we remember everything about you told your in-laws are hospitalized. Then you started arguing. So there are still 15 minutes of time. You go ahead. We will take up tomorrow. Why next Monday? So why not after vacation? What is this matter? Not fair, no, to the opponent. Not fair to the opponent, right? You please argue. Please. Yes, go ahead. Yes.
Always 125 for declaration and activity. What is allowed to be written.
You told us all that.
Now they go, my mother,
We will tell you what you have told. Your mother is a Christian, your father, and those days there was no act. So therefore marriage took place and all that. And then you sued as a pauper declaration, that relief has been struck down. Only possession, right? Ah.
Not considered my pension book exhibit fee 19 your lordship. In pension, your lordship will kindly see. I am also government servant. My husband is also government servant. Both of us are government servant. My pension book, my husband is mentioned as SL Murthy. It is also mentioned. I will get back to 1984 your lordship. I got it right. 1984 is mentioned. After me, the fact pension we paid to my husband is a Murthy. Exhibit fee 19 dollars. UOS 135 dollars. So as not repeat to it. It says that in the pension books, so the operating particulars the order the pension book does not mention the date of marriage. Pension book does not mention the date of marriage. And coming to other exhibits, 48 exhibits, out of 452, only few documents. Exhibit P20, exhibit P22 to 25, exhibit P40 to 42. What are these exhibits? P3 are all the letters written by my husband for a period of more than 30 years. And every letter has a signature of my husband. The letters have been marked from 3 to 80 and the signatures are respectively and 8. Coming to the exhibits P22 to P25, can we see? P22 to P25 are the transfer the certificates of my children. That is the case. Even in this logic, it is mentioned that the father is a Murthy. Hindu. Yes, it's an accurate fact. I'm not that was the court says, according to the old evidence of P21, my mother evidence is of P21. Here that P20, P25, P40, P42 are the transfer certificates. I created one government only for the purpose of this case. How could this be possible, your lordship? When we were born in 1964, 62, 61, when I put them into the school, government school, I was a government servant. I was placed in all the pockets of the Karnataka in all the villages. 60 to 18 villages were at the I was in my of course, they are not marked as documents. When 10 marks start, cannot be created your lordship. Court says one sentence. It is clear that P22, P22, P25, P40 to 42. What are they? P20 to 24 are the transfer certificates. P40 to 45 are the in the OS, two contention. It says, I do not know the statement. Second, he says that I know them. I only saw the painting. That is my mother. Only the year 1950 and there is another contention. How could this be possible? I got it in 1984. So I know that in 1990, my husband is living in the house where his father and he was living. You sell the property, property is owned the husband. I know that there are many this case of me telling the applicant, how can these documents can be managed? And other than that, no other evidence of course. We can do also few documents are marked. Can you look at these documents? Very important documents for logic. Exhibit 44, 45. What are they? They are the letters to RTI in the Orient Hospital. Way back in 1986, I went with an accident. I went to meet my husband. I came home to the bus stand to meet my husband. I met with an accident. The bus experience was come from me. I was unconscious. They asked me who inform. I said, my husband is working in the other market, he's having a fish stall. Go tell me, inform my husband. And that evidence report, P44, shows that brought by the husband. Is P44 a lot. Can I say that the lower court does not speak anything about that exhibit? The other document is P45. Even by the DC, can I consider the order of the DC or order? My brother is a mentally retarded person, and the DC has appointed me as a guardian. They are looking at my father as a movie. Out of his one is mentally retarded. Was very at the age of 18. I do not know what happens. Every month, injection and take now already 60 years old, and every day I have to take 4 tablets. So in that order also, guardian is the of DC. That also the court does not consider. Does not speak of this for God a sentence of the exhibit P45. When after the image of my mother, 2001 my father died. 2006 my mother died. After the image of my father, I got to know there are so many documents in that trunk which we could not mark in this OS1 that time of 1999. Very SN40, we're back in 1951. He writes a letter to his mother. SN40, care of Rosemary Francis, midwife. My first appointment is near Chitradurga. They were visiting in my house, right? So even the parents of SN40 knew about the relationship between me and SN40. I was very, because both the government serving, his job should not be affected, and his parents. He was very close his property. 8 properties were lodged. 8 properties he had. I'm not telling you everything. Even in this also, there are so many other numbers. Only very carefully. Each property I got a each property. So my maintenance. All the other stuff and all the sources are taken, and he was giving to me only. For my children only. So the house where his father lived, 1990, there are actually too many places here. After the experiment, I was saying, he brings me alone, I cannot pay rent, then pay for come here, he brought me. I was bankrupt. Even the marriage, they mentioned, I do not know for what purpose my mother had kept it in the front. I found 2 documents where one shows that she was baptized on 1929, another one in 1951 to be married. Those 2 documents are also I found before this one, but however, they are not found as an exhibit in this case.
You can't place it, madam, like that.
You cannot place it. Madam,
Go ahead.
these are the 2 documents of the lower court has not been even otherwise the process. Coming back, apart from the exhibits, defendant takes to condemn the written statement. Defendant number 1. He says, I do not know Brady at all. He says, Brady, 1 and not my wife, and the other 2 for a lot of children. He said that one sentence. Another sentence, I only came to know about the Brady year 1990. Now coming to the court, or anything. Different number 2 and 3 are none of these. Otherwise, of different number 1 and child form of that clause. Even they did not file the different 2 and 3 adopted remove stating that they are not in the 1. Like they come before the court, they are not equal, there is no evidence. In OS 135 suit asking for a declaration, evidence is done by the 4th and 5th defendant who are the one who purchased the property from my state husband. The year 1998, till 1998, I if you see, it has got more than 8 properties a lot. I'm not claiming this. I know you did all. This is some of your lordship. My husband, my dog gave birth to another 2 ladies is got out of which 5 children to SN40. And these 3 children are in the property of 10 properties of SN40. Not that the 5 children are. Only the one who may invest 2 or 3, they are staying in one property. He is also a government teacher. I was not a government paper is working hospital. Only 1%. I don't draw on the seats. Nobody is saying, I think that litigation. The other relevant council takes the condition that he got the property to be registered from his father, so he sold it. Even that deed is a decision of my husband. So this is great. Because of the 4 daughters and 2 sons, one of the brother also died. When the brother does not have issue. Only brother does not have issue. Only brother, wife was not in any of the property. She's also down somewhere. No one is in the property, all are under litigation. This is both the entire property should pay 3,020, some change, I am only staying 1,000. He is the one who pays because 1998, Modi paid the electric water bill. Modi gave all the rents of other shops. The paying the rent. The agreement like when his parents knew that I've been married to you. He never
admitted. You said admitted. Who has admitted?
But his parents knew. Parents knew. In 1951, he writes a letter to his own mother. I paid 10 rupees to Francis, Rose and Francis, because he wanted for something like that. Some education. In 1951, he wrote. So he said, my dear mother, mom, that is his mother. That is who his mother is ready. I think he job in 1951 March. He got wedded in April. Because he was worried about his property. All the property are under the bill he has taken. That is the reason he also filed a partition and then he became in their favor. But they have not added this property because they by the time they filed a partition, this things and taken into the one. Apart from this, they will fix for this. I will continue.
Tomorrow, we'll continue. Go ahead, still time. Why? We are listening to you. All patience. All patience, you keep on asking questions. We are not going to answer them. Please rest assured. Okay, can I do it? Can it be forced? All these questions, you will find the answer in our judgment. Don't put questions to us. We are listening to you with all patience. Please argue. Good.
One sentence that none of the documents has been considered by the lower court. One sentence only documents. Other two documents are 48 exhibits alone. No, ask me to go ahead and go ahead. There are 48 exhibits. Every exhibit I need to speak of 2 explain one documents.
No, this is not done, madam. Like you would have exhibited 100 documents and you would read everything. Tell us. There is nothing to read about this postcard, which is a letter. Why should we read it? And this is a correspondence between you and your husband. Why? That's good enough to tell us. Go ahead, go ahead. Instead of arguing, doing all this, please go ahead. We are hearing you. Why are you interested in this thing, seeking adjournment? We are hearing you.
Yes. 45 years.
You should go ahead from P1, right? Or you will jump like that. Yes.
ತಂದೆ ಶ್ರೀ ಸತ್ಯನಾರಾಯಣ ಮೂರ್ತಿ ಅವರು ದಿನಾಂಕ 26/1/2005 ಸೋಲೂರು ಮಾಗಡಿ ಇಲ್ಲಿ ನರ್ಸಾಗಿ ಸೇವೆ ಸಲ್ಲಿಸಿ ನಿವೃತ್ತಿ ಹೊಂದಿ ಪಿಂಚಣಿ ವೇತನವನ್ನು ಪಡೆಯುತ್ತಿದ್ದರು. ದಿನಾಂಕ 8/1/2000 ಮರಣ ಹೊಂದಿರುತ್ತಾರೆ. then when they passed away, the date is being mentioned in the guardianship certificate, Your Lordship. Because this is the order of the DC, Your Lordship. ಮತ್ತೆ ಇಂಥವರ ಕುಟುಂಬದೊಂದಿಗೆ ವಾಸವಾಗಿರುತ್ತಾರೆ. ತಹಸೀಲ್ದಾರ್ಗೆ ಉಲ್ಲೇಖಿತ ವರದಿ ಮೇರೆಗೆ ಶ್ರೀಮತಿ ರೀಟರ್ ಅವರನ್ನು KCRSR ನಿಯಮಾವಳಿ 347 ಬಾಬು ಪ್ರೇಮಚಂದ್ರ ಅವರ ಪೋಷಕರಾಗಿ ನೇಮಿಸಿದ್ದೇನೆ. The certificate, I mean, order of the TCR. So here it really clearly mentioned that also in the parents of the one of my siblings is mentioned that
Certificate is issued at your instance.
because this certificate has to be there for the medical treatment.
It has been issued at your instance. He is not a party to that. Issued on the basis of the information given by you.
Yes, Your Lordship. Yes, I agree. I agree. The next document is 43, Your Lordship. After the P44 to PW2, broad fire and bed. Column number 7, Your Lordship.
Exhibit 43.
44, 242, PW2. Column number 7. Broad fire and bed. I told the client as well as the client. So, patient is in conscious. In column number 2, Your Lordship. Same. Column number 2. Address of the person who brought. Door number 31, first class, Oklahoma Garden, status in forum, Bangalore 82. Yes, that is the address where this is was made.
What is his name?
That only said brought by husband.
His name is not mentioned.
Name is not mentioned. Address is the address only. The father is standing in his name and it's been yes, you made a gift seat in 2001 just before his death. 2 is by Sarojini. That is the second wife.
Tomorrow, madam. It continue tomorrow. Come out, yes, very yes, please. Compromise. Ah. 68. It counted for the party 68. Pray for adjournment to enable them to settlement list on Monday is what? 11th April. Want to withdraw? Want to withdraw that petition? It continue. These matters will be, all of them will be repeated tomorrow.
Let in 79 stay to be extended. Stay is only till the next date of hearing.
Lord, serial number 61, my lords, I appear for the respondent.
And over in November 2021, the appellant has finished his argument and respondent's argument is pending. This is under the head of further hearing part.
I appear for appellants in this
That
matter.
was heard by a different combination earlier.
Lord,
That
I
was
appear
heard by a different combination earlier.
So it was under final hearing.
That was heard. When was it
Not by
heard?
this bench.
November last year.
November, it was.
Same comments.
No, my lord, it was a
We
different
don't
topic.
remember, right? We don't remember what we heard in November 21.
Posted under the head of further hearing.
No, we don't.
My lords, I appear for appellants in this matter, my lord. It was heard, my lord.
Fine, right? It's what is there to? I mean, it's all being repeated tomorrow. We don't know.
Please, my lord.
My lord, 61, my lords, I appear for the respondent. May I request for a week's accommodation?
Right? No. Let the counsel for appellant be there. He is not there. Please, you make a prayer when you appear.
Please.
Everything will be repeated tomorrow.
Your Lordships, with your kind permission, if I may be permitted to make a submission. Your Lordship, serial number 76, I appear for respond number 5.
We can't take up any case, madam. It's 450 now. Right? So, if you want to argue a case, it's not possible.
Your Lordships, I wanted a longer date. If the list is going to be repeated
that's what
tomorrow.
We are saying tomorrow.
Your Lordship, there's
Take
some
a mention.
inconvenience.
No. Tomorrow you are not available. Huh?
Yes, Your Lordship. The council on.
If you are not available, fine, madam. We will see what is to be done. You tell the court officer, you interact with him, he will give you a date, whatever. Powers of adjournment have been delegated to him. He will deal with it. There's nothing urgent in mentioning a prayer for adjournment at 450. We would have understood that if you wanted to argue the case. What is there to seek an adjournment? Tomorrow also you will seek an adjournment.
Apologies.
Court officer, serial number 79 ಒಂದು ಸ್ಟೇ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಬೇಕು.
Court officer,